all persons having business to do before this court will draw near, give their attendance, and they shall be heard.
Good morning, everyone. You may be seated. First case for oral argument today is 1035 People v. Logan. Good morning, Counselor.
District Attorney isn't here, so I'll be brief. This is an appeal from the conviction for the crime of forgery in the second degree. Following a jury trial, the defendant got 3 to 6 years in jail concerning the check passed at a bank. First issue we'd like to discuss concerns the photo array. It's our position that the DA did not satisfy its initial burden of showing reasonable conduct by the police concerning the methods used and the photograph itself. When you look at the photographs that are in the appendix, you'll see that my client's photo is darker than the other photos.
Was that part of the motion down below? The color of the shirt?
Unfortunately not.
Okay.
Or the fact that one of the participants has a bandage over his ear, which obviously would disqualify him right off the bat. And the photos, the array was not changed at all, and the sequence, and the individuals were not admonished not to talk to each other about.
No, Counsel, I don't disagree with you. That would be obviously the better practice, but is there any evidence before us that there's been any communication between the parties regarding the photo identification?
No. The only problem with the photo identification at the trial was that the district attorney brought out with the witness, from one of the witnesses, that there was a photo array, in which we all know is improper, and the judge says
at the time it was, and now it's not, right?
Pardon me?
At the time it was, but the legislation has changed since then. It doesn't matter, but
right.
At the time.
Well, that's not till next year, is it?
Yeah.
Lost my train of thought. He said next time it happens, I'm going to declare a mistrial. It happened again, and he didn't declare a mistrial. So
did he request one?
No, he didn't, and I think he said that he didn't request one because he didn't want to highlight it again, even though it was highlighted twice. And we submit that the evidence was insufficient insofar as the corroboration of the accomplice testimony, and other than that, we'll rely on our brief.
Thank you, Counsel. 1036 People v. Lundy. Morning, Counsel.
Good morning, Your Honors, and may it please the Court, Peter Banishak for Mr. Quincy Lundy. I'd like to focus on the first 2 points of our brief this morning, unless the Court has any questions about any of the other issues. Starting with the first point, the unique circumstances of this case show that under the Court of Appeals decision in People v. Payne, Mr. Lundy should have been granted a separate trial from his brother, Dron. Dron not only confessed to the crime, but he specifically said that he committed the crime because he thought Jason Acevedo was outside of 644 Catherine Street, and the shooting was a result of the feud he was having with Jason Acevedo and Alfred Thomas. On top of that, he confirmed that Quincy was involved in the very same disagreement and recounted hearsay statements directly implicating Quincy in the homicide. And in particular, he recounted that he was told by Jason Acevedo's own mother that the word was that Quincy was involved in this crime. On top of those statements, there was irrefutable GPS evidence that really left close to zero doubt about Dron's involvement and therefore his direct knowledge of what occurred here.
Well, he didn't claim he was with him, right?
That part of his statement was redacted. I think, though, given that he recounted the hearsay statements about Quincy's involvement taken together, that has the same impact on the jury as his own statement that he was there with Quincy. I think
so your argument is that the conflict that exists could lead to somehow or another the defendant's guilt.
It's not really about the conflict that exists. Under Payne, it's about whether the evidence that otherwise would have been excluded fills in gaps in the prosecutor's proof or otherwise shores up areas of reasonable doubt. And I think...
Okay, so why don't you marshal those for us?
Sure. So I think perhaps the most significant aspect of this is that one of the defense contentions and perhaps one of the issues with the prosecutor's proof was, if this shooting was a result of the feud, why were two unrelated people targeted? Walter Bell and Shavaki Bloodworth had nothing to do with this feud aside from knowing the other individuals. Drawn filled in that gap. He said, the reason we targeted that house was because we thought Jason Acevedo was out there. So that, I think, created a strong link in the people's proof that otherwise would not have existed. It also corroborated Jason Acevedo's testimony. He otherwise came forward more than a year after this happened, when he was facing 20 years in prison, and all of a sudden comes forward and tells the story about having been there. No one else really corroborates his presence there. Drawn's statements, however, provide corroboration that he was there because Drawn saw him there. Drawn also said that he had heard that 3 people were involved, and Acevedo was the only one who claimed that he saw 3 people, so that provided additional corroboration, which simply would not have otherwise existed for a witness that certainly was not a model of credibility or reliability. And I think severance is unique because this court looks not only at the record as it existed when the trial court made the decision, but it has to look at how the trial itself unfolded. And here, Tamika, with respect to Tamika Hollister in particular, she's the woman who allegedly observed them walking down the street. Defense counsel for Drawn negligently elicited the fact that Hollister identified Drawn in the photographic array, which caused confusion before the jury about whether she actually identified both Drawn and Quincy. And they were under that misapprehension for seemingly the entirety of the trial until they sent out a jury note. While that misapprehension was ultimately corrected, the reality is that the jury, and what the prosecution argued on summation is, given that she identified Drawn in a photo array, that should give you confidence that she got a good look at both of the defendants, thus really bolstering her testimony. Without Drawn's statements and without the evidence against Drawn, without a joint trial, none of those facts come out, and Jason Acevedo's testimony stands on its own. Hollister's testimony also stands on its own. And under these circumstances in Payne, the Court of Appeals said when you have a confession by a co-defendant that implicates a defendant, as it does here, you could really only have confidence that the defendant was not unduly prejudiced when either the defendant himself made nearly an identical statement or the proof is otherwise strong. And neither of those things are present here. Quincy did not make an admission, and the proof, I think, as shown by the deliberations, wasn't overwhelming. The jury deliberated for nearly 2 days, and they needed an Allen charge. And so under all of the circumstances here, it's just highly unlikely that the jury could have easily sifted through all the proof and considered it separately against each defendant. It's much more likely that they could not have done that, even assuming that these limiting instructions were given as they were in the trial in Payne. I think it's also significant that the co-defendants here were brothers. There's already a natural inclination to make an inference of guilt by association, and I think that makes it even more difficult for the jury to view the evidence separately when they're already viewing this relationship as one that's close and one that likely, and in a case that likely involved both of them. So for those reasons, we respectfully submit that Quincy should have been granted a separate trial, and we ask this court to grant him one. With respect to the second point, we've raised a few issues regarding defense counsel's shortcomings. The one that I'd like to focus on this morning is defense counsel's failure to investigate and call as a witness both Shavaki Bloodworth and Samuel Massard. The lower court and respondent now argue that there could have been a strategic reason for counsel's failure to call those witnesses. Our position is that the question is much more basic than that, and that is, did defense counsel conduct the minimum investigation that would have even put him in the position to make a strategic determination? Here, had counsel done so, he would have learned that Shavaki Bloodworth, although he could not identify the shooters, he knew that Quincy was not involved, and that's obviously...
Yeah, but it seems to me, at least from originally, didn't the statement say he didn't know who the shooters were? And then the subsequent statement is it wasn't, basically, in essence, you can read it as saying, I knew that one of the shooters wasn't so-and-so.
That's correct. I don't believe that's inconsistent or incompatible, because I
Yeah, your
think...
view is that doesn't change it. In other words, that's fine. I didn't know who it was, but I did know it wasn't the defendant.
Exactly. I think I could look at the courtroom right now and tell you that I don't know who these folks are, but they're not my father or some other acquaintance of mine, and those two things I think are compatible. And defense counsel really had to know that information in order to even be able to make a strategic decision, and the failure to conduct that investigation, I think...
Did he try to interview him?
There's no indication that he did. Mr. Bloodworth said that he was not contacted by counsel. Mr. Lundy attempted to obtain an affidavit from counsel. He was unsuccessful in doing so. And I think in that respect, at minimum, there's a question of fact here where a hearing should have been held. We cited People v. Borsick in our reply brief that this court, I believe, decided last year, which involved similar circumstances where there was a question of fact. And I think the overall failure to conduct the minimum investigation puts this case on par with People v. Olivares. And so if this court does not otherwise reverse the conviction, we would respectfully...
I have one question.
Sure.
I forgot to ask when you were on the first point. Did you say when you started your oral argument that Drone confessed to the crime?
Yes. He did so to Maurice Manuel, not to the police, but
To his cousin.
To his cousin. He told his cousin that I did
Right, okay,
I
to the
did
cousin.
that.
Got it.
I thought
But he
it was
didn't get
Jake.
on the stand and confess to it. That's why I was confused. Forgive me.
I'm sorry. Yes, he told his cousin he did that. He did it because he thought it was Jason Acevedo. It related to the feud, and I think that was powerful evidence to connect the gap that otherwise existed. Thank you.
Good morning.
Good morning, Your Honors. May it please the court, Ken Tyler for the people.
What do you say with respect to the claim that gaps were filled in, that the defendant was prejudiced by the testimony as it related to Duran, and therefore severance should have been granted?
Well, I think that goes to the point that, as the Court of Appeals said in Mabubian, there's some degree of prejudice that results from any joint trial, and that's the kind of prejudice that occurred here. I don't think there was an absence of evidence that would have been present if Quincy had been tried by himself. And I would point you to the fact that Detective Ocon testified, the defendant made a statement to him that he had gotten in a fist fight on Butternut Street on people associated with this group of people. His own grand jury testimony was admitted at trial, in which he referred to the fact that Acevedo and Thomas shot up his house. I believe it was Duran that called his mother to testify, and the mother actually substantiated Quincy's purported alibi that he was sitting at home. She testified that her house and vehicle had been shot up 3 times. The evidence of a pre-existing feud, and of course the people don't have to prove motive, but the evidence of a pre-existing feud did not come solely from Duran. So I would submit to you that the prejudice, any joint trial has some degree of prejudice. I can't dispute that. That's just logical. But the kind of prejudice we're referring to here would not require severance of the trials. The test is set forth in Mabubi, and there was the core of each defense in irreconcilable conflict, and was there a significant degree
Yeah,
to
in
which...
this case, if you really just apply the idea that the facts that neither said they were with the other or implicated the other.
That's it, and that's exactly the point we make on our brief. Their defenses are not at all incompatible, and in fact, Duran's aided Quincy's. He said, Quincy wasn't there. I overheard he was on the phone, with my mom.
His argument seems to be much more broader than that. He doesn't dispute that they're not incompatible. It's just that facts that would have been, that are being allowed in against one defendant affects, it fills in the gaps that are prejudiced, at least my view of it, as the argument is the co-defendant, the defendant here, excuse me. That's-
I understand the argument is a little broader than the narrow test set forth in Maboubian, and I would submit to you that the evidence wasn't so much stronger against Drawn that, separate trials were mandated. There was significant evidence that would have been admissible against Quincy even in his own separate trial. The defense counsel makes the point that, it was Drawn that called the mother to testify. Well, the mother's the one that substantiated his alibi, said he was at home with me. And the fact is, even in a separate trial, the people could have called the mother if that was deemed appropriate under the circumstances. So I don't think that serves as a basis for severance here.
What about the 440?
With respect to the 440, as Justice Curran pointed out, and I guess this goes back to point one, but I just wanted to highlight it. I don't think Drawn confessed to the crime in the sense that he made a police admission. There was evidence of a statement he made to his cousin who was incarcerated. With respect to the 440, the police reports, which defense counsel clearly received, all reflect that Detective Oken spoke with Shavaki Bloodworth, I believe, 4 times. And I disagree with the idea that he was consistent from day one all the way through the 2 late blossoming affidavits he provided in 2016. At first, he didn't say, I couldn't identify the shooters who were there, but I can tell you for a fact they weren't Drawn and Quincy. I believe what he said was there was only 2 people outside at the time of the shooting, and they were Walter Bell, the murder victim, and myself. And another statement he provided to Detective Okan, based on Okan's testimony and reports, was that the shooting resulted from a fight that occurred on Butternut Street. That's Shavaki speculating, but that is exactly the people's theory. Quincy had a pre-existing, motive or feud going on. There was evidence that he was the person involved in a fight on Butternut Street. So our position is that the record itself provides ample reason to support the conclusion that it was a reasoned decision to not call Shavaki. And I would just like to make the point, I understand that the argument, again, with respect to point 2 is broader, is that he had to defense counsel had a duty to at least, investigate Shavaki to see what he would say at that point in time. I believe at one point defense argues that they should have hired an investigator to track him down. The test on an ineffective assistance of claim, whether it's raised in a 440 or on direct appeal, requires defendant to demonstrate the absence of strategic or other legitimate explanations for the conduct. There are legitimate explanations in this record. And that includes defense counsel's prompted response to, I believe, an inquiry from the grievance committee, presumably triggered by Quincy, in which he said, well, I see I'm being asked to file an affidavit explaining why I didn't call Shavaki Bloodworth when 2 years later he has changed his story. For all those reasons, I would submit to you that the hearing was properly, 440 motion was probably denied without a hearing. Thank you.
Okay, 1038 submitted. 1039, Brooks v. Brooks. 1039, Brooks v. Brooks. Team submitted. 1040, it's Tarquig and Ashley B. Good morning, Counsel.
Good morning, Your Honor. I'm Charles Greenberg on behalf of Ashley, who is arguing that the courts below, the Erie County Family Court, should have ordered the genetic marker testing.
Okay, Counselor, let me get to the
Sure.
core. I guess the question is that, has the party been aggrieved? The mother's appealing here, correct?
Yes.
Okay, she nobody didn't request any relief from her. She really wasn't a party to it. She didn't ask for the relief. You know what I'm saying?
Yes.
So it appears to me here that the person who claimed to be the biological father or the father acting as the father, either or, are the ones that brought the petitions, and they never appealed.
Mm-hmm.
So in order for it to be for us, how do we have her as an aggrieved party to appeal?
That's a good question, and I have to admit, I just assumed that she was because it was never really mentioned because it was her appeal. I would argue that she's aggrieved in the sense that the person who is not the father is being made to continue in that role as a result of not arguing, not bringing in these genetic markers testing. She has to have a relationship with his father, with his
Yeah, but she
putative
didn't- I
father.
think the point that Justice Sentry's making, she didn't oppose the application below.
That is correct. So, I mean, maybe if you're defining aggrieved in a very narrow sense of the word as defined in, I don't know.
Well, she
You know.
didn't seek to vacate the acknowledgement, did she?
No, these were
But she
something
could've.
that she could have, but it was basically the fathers who did these things. It was the father, or one of them is the father that they, so. Okay, I mean, no, she was the respondent. This was something that the petitions that they brought. I mean, she supports the idea of the genetic marker testing, but she wasn't really a party to bringing it. It was something that the two fathers, or one of them, I'm using the word father in the putative sense of the word. I wasn't there for any of this, but it was something that they did. So if you want to define aggrieved very narrowly, then,
Well, she didn't join in the petitioner's request for relief either, did she?
No, she was strictly a respondent, and she was there to agree to whatever they were agreeing to.
Okay, thank you.
Any other questions?
If it pleases the court and counsel, with respect to the court's point, I think that's a very valid point, that she lacks the ability to complain about what occurred since she didn't take any affirmative action in the trial court below to seek relief. With respect to the decision itself, I believe it's supported in the evidence that this child had a deep relationship with the Mr. Salah. She bore his name. She barely knew this putative father, and even previously, prior to trial, had only seen him less than a handful of times in not 2 months prior to the trial. So in my opinion, it is in the child's best interest. What the court did ultimately supported that. I don't know if the court's interested in an update. I do have an update on the parties did go ahead and do what they wanted to do. Essentially, my client believes her father is Bill. She doesn't know his last name. She sees him only sometimes because he works a lot. She only sees Mr. Salah, who she formerly thought was her father, when he comes to pick up her sister and takes her sister for access.
Thank you, Counsel.
Thank you.
1041 Haynes v. Ramos. Good morning.
Good morning. My name is Chris Thomas, and I represent the petitioner appellant, Ms. Haynes. I'm here with co-counsel Brett Figluski, who litigated the Brooke S.B. case at the Court of Appeals, and with my colleague from Nixon Peabody, Zach Osinski, who's been with me on this case from the beginning. This has been the most important case of my 27-year career. The issues matter so deeply and so much to real people, underrepresented people. Ms. Haynes and her family are here in court today, and many others are watching by way of the live stream. Your decision on this case will affect them, their child, their niece, their grandchild. May it please the court. There wasn't a sound or substantial basis in the record for the decision below. It was riddled with misstatements and incorrect assertions of fact, and this court should use its powers both in law and equity to reverse. Petitioners' standing should be recognized by this court on this record. The biological father should be estopped by this court on this record. The case should be sent back to Monroe County Family Court for one purpose only, and that is for...
When you say with respect to estoppel, the reason that you are asserting estoppel is the conduct claimed to have occurred by the father before the child's birth?
and for the 3 years following the child's birth.
But then he was adjudicated to be the father.
He was adjudicated to be the father, but by that time, because of his active actions relative to the child and relative to the biological mom, he completely abandoned his rights as a father, and he allowed for the relationship that flourished and continues to flourish to this day as between...
And then below, he says he didn't simply consent to being substituted as the other parent, correct?
Well, that's what he said.
That's
yeah.
what he said.
That's what he said.
And the trial court was in the position to make determinations with respect to credibility?
With, that is what the trial court said. However, respectfully, it was egregiously incorrect.
He didn't take action to back up those words, though, early on, did he?
Wait, I'm sorry, say
He
that?
didn't take any action to back up those words or to make those words truthful.
Well, what he did was, when biological mom came to him in the days after she learned of conception, this was probably at week 6, week 7, week 8, and said, "We've been having lots of unprotected sex. I am now pregnant. I have not been having sex with anybody else but you." And what was his response? "There are words that I can't use or I don't want to use in this courtroom."
Essentially, get an abortion.
Yes, and also just said the meanest possible things that a man could say to a woman that he had impregnated.
Well, Counsel, let me try to focus in on what I happen to think one of the core issues are here. Let's just assume you're right on your argument on the court's determination. Should I say, whether or not the court improperly interpreted the facts. Let's just assume that. We begin with the premise, and it was raised here, of Section 70. We have to show a party has to have standing. And in order for a party to have standing, you're alleging that you qualify under Section 70 of the domestic relation law. Is that correct?
Correct.
Okay. And it seems to be further that we have a situation here where Section 70 says what Section 70 says. And it says either parent. And I think that's clear of the statute. And then there serves to be some argument from attorney for the child and the parties here that Brooke S. somehow or another expanded that. Okay, and the way I read Brooke S. to some respects is that Brooke S. expanded the definition of parent to not only to include more than just parent or adoptive parent. Would you agree with me up to that point?
I would agree that Brooke has completely flipped the landscape, and it has found standing for non-biological, non-adoptive parents.
So,
based upon the excuse me, I'm sorry to interrupt. Based on the relationship, based on the facts on the ground.
And so we have a situation there where Brooke S. says, hey, we shouldn't hold this parent to just this nominal, narrow definition. We should open it up, and that's what the Court of Appeals did on Brooke S. That's my interpretation of it. We're still stuck, and this is where my problem begins and starts, is we're still stuck with the statutory interpretation of either parent. Now, I know you didn't argue this, but I believe attorney for the child argued this, and I asked him, is that the footnote in there was just dicta, when it referred to just two parents.
Right, and that's what the case of David S., 59 miscellaneous 3rd, 960 of 2018 post-Brooke S. case said specifically. It noted regarding DRL 70, Your Honor, this court finds that the dictum in footnote 3 of Brooke that a child is limited to no more than two parents who have rights to custody and visitation under DRL 70 is contrary to the spirit of the decision and is not being followed here.
And there's a situation where nobody's objecting to a tri-parent relationship. The court makes that determination, and it's a miscellaneous case. But we're still stuck with me, whether it's dicta or not, is the interpretation of the statute. And that's where my problem is on this case. I'm sympathetic to the situation, and I understand it, but it's still a legislative situation where the definition is either parent. And how do you help me get around that?
Well, I'd say that the Court of Appeals has said that the court, it has discretion to interpret these, and that's what we're arguing here. There's no question that that's the nub. You put your finger on the nub of the issue here. But the court has
that there can be, under the statute, a tri-parent situation.
I'm sorry?
That there can, in reading section 70, there can be a tri-parent relationship.
Yes.
And that's harmonizes with the statute.
Right, and I think the court, in the breadth of that decision, is saying to us, is saying to New York, look, there's a lot of different looking families that are out there, and what do we care most about in family court? Children. That's what we care the most about. Do we care about adults?
And
Yes,
there have been instances where, as it's been stated, there are tri-parent relationships that are acknowledged. The difference here is that they're not all in agreement. In one instance, there was a case wherein the divorced father, the biological mother, and the stepmother all agreed to tri-parent. How do you deal with situations where all are not in agreement?
Look, grown-ups have to be the grown-ups in the room. And I think part of the reason, and I'll defer to the attorney for the child who knows this case like the back of her hand, would say that, frankly, family court emboldened Mr. Ramos. And if there is a decision that comes out of this court that says adults have to behave like adults, they will get along.
Well, let me ask you this.
Go ahead.
If we don't read the statute to mean there can be a tri-parent relationship, is it game over for your case?
Well, we'll appeal, of course.
I mean, in other words, do you have another theory? Because I get the equitable issue. In other words, we have an obligation to read the statute and see the plain reading of it and make an interpretation of what it means. Does either parent mean two individuals, or does it mean more than two individuals? But let's leave that aside. I know that's the whole case here, right? I'm sympathetic to the step that you started to talk about, all the equities of why this individual should not be, the dad should not be deemed a parent, or maybe wouldn't have been, but for this one act, mom filing a paternity action. And so do you have any other argument if we don't agree with you that the statute doesn't allow for a tri-parent relationship?
The argument that, first, I'm not sure I agree that, so the way that the paternity...
What don't you agree with?
Well, I'm not sure we're in sync about how Mr. Ramos came into the picture at all. So
well, you started to talk about how Mr. Ramos didn't want to be in the picture.
Well, he totally wasn't in the picture.
But then what happened, what I added to the inquiry was the fact that there was a paternity petition filed thereafter, and he was deemed the dad. And in fact, the parties stipulated to joint custody with him.
Yeah, so what happened was...
So you understand that that's a problem?
I understand that's a problem, but the way it came about was that there had been an application for public assistance. Mm-hmm. Nobody wanted, including Mr. Ramos, nobody wanted him in this relationship. And it was only because of this application for public assistance that he was forced to take this paternity exam. And remember, he stood in open court in front of hearing officer Gordon and said, he pointed at the biological mother with whom he had been having lots of unprotected sex and said, I don't even know who that woman is.
I don't know why I'm here.
I don't know why I'm here. I mean, come on.
Yeah.
So
and that's,
that was
I guess,
the reason.
My point. I guess that's my point. My point is we have this judicial determination, and you may have a whole host of equities on your side relative to his relationship with mom or the child, but we have this hurdle of what this paternity finding and this stipulated joint custody arrangement, and then we have to try to apply that, and then we're stuck with a situation where we have to say, what does the statute say, and what does the statute mean? So your argument's limited to that. You think that under the statute, it allows for a tri-parent situation.
Yes, and I think that the court is inviting that inquiry. And I also think that both the Troxel case at the United States Supreme Court, as cited in Brooke SB, is critical here, and it goes to the very core function of family court. Here we do not consider they were thinking about the rights of the child, the constitutional rights of the child.
And
that is
here, the petitioner was arguably spending more time than the biological parents in some respects. Some of the things that she was doing for the child, taking her to lessons, being consistently present. Your argument is that the father came about not because he volunteered to be in the true sense a father. It was because he was petitioned because of the social services.
Yes, Your Honor, and the evidence is clear and convincing. I would argue that it was beyond a reasonable doubt, even though that's not our standard, that Tamika was doing all of it. The child has been living with her.
And Counselor, I recognize that we're familiar with the record, and I'm saying, assuming for argument's sake here today, just for argument's sake, you're correct on every issue you're raising. To me, it comes back full circle. Does Brooke ask, does that not only mean that it can be a non-biological parent, it doesn't have to be an adoptive parent, does that definition that it opened up, does it broaden the legislative term of either parent to be multiple parents? Because you'd have to agree with me, this could happen in a heterosexual situation where you have step-parents that could be in the same situation. So it's really dealing with the thing of the statutory interpretation, and that's where I tried to focus myself on is the fact that if we get there, how do we get around the statute?
Yeah, well, and the second department has been so prolific in this area. Obviously, they get far more of these cases than the third or the first or the fourth. And they have consistently recognized that post-conception agreements can be acknowledged, can be effective. They have consistently recognized that that there are equities that are involved, and that the focus always is primarily on the best interest of the child. And I'm so thankful that the amici submitted their brief, and with it is the scientific data that was submitted to the Court of Appeals regarding attachment.
Mr. Thomas, let me ask you this.
Yeah.
We're familiar with what's been submitted, we're familiar with the record. Tell this panel how either parent means more than two.
I think that the New York State Court of Appeals has taken the view that this is an area that is within their purview to interpret. And I don't believe that they will...
And by that you mean in the Brooks case, they expanded the definition of parent.
Yes.
And you talked about how it, I believe your words were something to the effect of flipping the landscape. And
From Allison.
you said based on the relationship on the ground. The relationship on the ground there didn't invite them to define either parent to mean more than two. The relationship on the ground here, you're suggesting does.
Yes, it does, and that it's based in the best interest of the child, which controls here. The science is crystal clear about attachment theory.
But in Brooke, they looked at the definition of the word parent, right? If I recall the decision, they first looked at, is it defined in the statute? Isn't that the first thing we're supposed to do, right?
Right.
And they said it's not there. So then Justice Abdul Salam goes through all the different precedent that the court has, overturns Allison, et cetera, and finds that today this is what parent means. And that's the law of the land. But is either, the word either, defined anywhere in the New York State statutes? I don't find it.
And you're putting your finger right, again, we're talking right on the nub issue here.
If I look it up in Webster's, you know what I'm going to find? One of two.
Okay. Well, I think that the Court of
That's the
Appeals...
problem we're dealing with. So isn't the fix here at the legislature?
No. The fix here, today, in this court with this relationship is taking a look at the record on appeal, flipping that decision based on clear and convincing evidence that was introduced.
So are you saying that equity can cause the definition to be expanded?
Yes. And I think that the
Mr.
authority
Thomas,
that...
Mr. Thomas, is this somewhat like Judge Kaye's dissent years ago when she looked at the best interests of the child and looked at what case law for some 25 years or more that the court had, was looking at there, and the effect that that had, and that she wasn't willing to sign on to that, and you're saying that that's sort of how we then got to Brooke years later.
Yes.
And now you're saying this is the next step, and it's the same rationale.
Same rationale, and I think that, to your point, Your Honor, the Court of Appeals didn't close that door.
The footnote's pretty clear.
I think that if they wanted to close that door, it wouldn't have been in a footnote, it wouldn't have been in dicta. They would have said, don't bother sending any case that has a tri-parent arrangement to us. That's what they would have done. The door is open here.
Sometimes I wish they're a little more clear, too.
Wouldn't that be nice? Wouldn't that be nice?
But we get the same criticism, so.
Yeah. Well, thank you for your time and
Thank you
attention
very
to this
much.
important case.
Good morning, Your Honors. Maureen Poland, attorney for the child from the Legal Aid Society of Rochester. It's clear that you know the issues. It's clear that you know the record. I would like to address some of the issues that you raised with Mr. Thomas.
Yeah, let me just say this. I'm not on going down the wrong path. I just wanted to lay out some facts so that you understand that we understand what took place here. In other words, this hurdle of this paternity petition that gets us to the point where we have to define whether either in the statute means one of two. And so we're cognizant that if maybe this didn't take place, and we don't know what would have taken place between the relationship between these folks, the child and this individual, the father, we might, we wouldn't have to deal with this, because then we'd be dealing with the estoppel issue, maybe in a different direction, and then we would just have two individuals that Brooke S. has already defined what parent means. And so that's why I think we're all here and trying to figure out what Section 70 means and what the Court of Appeals meant with that footnote.
So to that point, Your Honor, I think that the Court of Appeals, when discussing domestic relations law section 70, noted, as has been noted, it did not define the term parent in the statute, and that prior to Allison D., New York courts would exercise their equitable powers in custody and visitation matters to make sure that the best interests of children were protected. And domestic relations law section 70 evolved in harmony with these equitable practices. Section 70 doesn't mention these equitable practices, although they were occurring. It does not purport to limit them.
I'm sorry to interrupt you, but by the way, this is a very sympathetic case. I agree with the justice presiding, and the lawyers have done a remarkable job here, so we're not trying to be critical with our questions. But if we use equity to interpret the word either, and forget about the dictionary, forget about that it's not defined in the legislature, can we also use equity to interpret the word shall? I mean, you get my point. Is I'm not so sure that that's our role in terms of interpreting a clear term either. It's like then we have the ability as a court to say whatever we want with respect to any word.
Or with any piece of legislation.
Yeah, that's what I'm struggling with, very honestly.
And I think domestic relations law section 70 is a bit different, because these equitable practices, according to what the Court of Appeals has told us in Brooke SB, these equitable practices were occurring, and the legislature was presumably aware of that.
But you would readily acknowledge that Supreme Court also has equitable power, that equitable powers are exercised routinely in surrogates court, and those courts all have statutes that govern them. And as your argument naturally leads to the point that if we use equity principles in equitable cases to interpret statutes, shall would be other than shall.
Potentially, Your Honor. I honestly hadn't given that point much thought, so I apologize for not having a clearer answer for you.
You see what we're struggling with.
I do.
What's interesting is this, is that with Allison, the court did come down with a decision and said, hey, this is what a parent means, correct?
Yes.
And then years later, in Brooke S., it came and said, okay, we're changing course. There's a much more broader definition of parent, and we gave it too narrow of a parent. So they changed one of their prior decisions on an interpretation of what they thought what parent meant.
Correct.
Okay, so what you're asking us to do is to take the next step and saying, since they meant that, they meant either parent means multiple parents, whether it be tri-parent, it could be 4 parents, it could be 5 parents. You know, where do we start and where do we stop? What if you have a situation where we have step-parents and step-parents and there's divorces there, and then they say, well, you know, we have an equitable interest in this and we should be considered, and so now do we come back in front of us and we say, well, we've gone to tri-parenting, we can go to four-parenting. It seems to me that the legislative aspect of either, if it said any parent, I think you got a stronger argument. A parent, I think you got a stronger argument. But when we deal with the word either parent, that's the conundrum that I'm in.
I understand that, and I go back to equitable practices that...
Counsel, as I understand what you're arguing, you're saying that the objective of Section 70 of the Domestic Relations Law is to promote the best interests of the child and the child's welfare and happiness.
Correct.
And that where the legislative direction, there's an absence of expressly what's meant, that the courts over the years have attempted to read these otherwise undefined terms to effectuate that legislative purpose, which is to the best interests of the child and the child's welfare.
Correct.
And that's your argument.
It is, absolutely. And I think that it is the best interests of the child and the welfare of the child that will define how many parents a child can have at the end of the day. You know the facts of this case, you know how compelling it is, and I think that it's important to remember that at the end of the day, it is my client, the child, who is innocent in all of this, who is going to suffer the greatest loss if we don't have this tri-parent arrangement acknowledged in law.
And for point of clarification, when you say the child will suffer the greatest loss, is it incorrect that the child is having contact with the person who has been serving such a significant role in her life that you are saying that she should be deemed a legal parent? Are you saying she's not going to have her in her life by virtue of a decision?
I'm saying that's certainly possible, Your Honor. There have been periods of time where the biological mother in this case has cut off contact between the petitioner appellant and my client. I met with the child about a week and a half ago, and I believe that there has been some cessation of contact between my client and petitioner appellant.
Yeah, so, you know, you need this standing so that, for the future, not just for the present.
Absolutely.
Stability.
Absolutely. The petitioner appellant is an incredibly stable force in my client's life. My client has been clear and consistent throughout these proceedings that petitioner appellant is her parent. She wants to have guaranteed parenting time with petitioner appellant. She wants petitioner appellant to be making decisions for her. She can articulate.
Parentage shouldn't depend on the whim of the other parents.
Correct. And, you know, notably, I understand that there's concerns 3 parents can be difficult. Where do we set a limit? But we don't say these 2 parents don't get along well, so we're going to only have 1 parent of this child. This other person shouldn't be acknowledged as a parent because these 2 cannot cooperate. That's not how this works. We have to look at what's going to be best for the child. And even if we have 1 parent who perhaps has sole legal custody.
So your point is, if you establish standing, you're not suggesting that willy-nilly the numbers increase. You're just saying standing gives the opportunity to go to court to then look at what is in the best interest of the child?
Absolutely. Absolutely. I can rest there unless the court has some other questions for me. No? Thank you, Your Honors.
Good morning, Counselor.
Good morning, Your Honors. Gary Muldoon, appearing for Jesus Ramos. The appellants would argue, the drift of their argument is that it's all about the child. I don't think it is. I think it's all about Tamika Haynes, about her right to be, supposedly to be, the 3rd parent. And you can't have 3 parents at the same time. I believe it was Mr. Thomas who says they shouldn't have put it in a footnote. They shouldn't have made it dicta. Well, it has to be dicta because it wasn't an issue in that. I'm sorry?
Why can't a child have 3 parents?
DRL 70. The word either.
Yeah, and isn't that, you're talking about the footnote. Let's assume that we were to interpret that case, and that footnote is to not to suggest anything, okay? It's dicta, you know, we're not bound by it. We still have the role here, on this case, it's really limited as Justice Centra started this, with his statement, that it's really reduced down to Section 70 and whether we consider that either to be more than one of two.
That is correct, Your Honor. And the suggestion is perhaps being made that 3 is better than 2. I would suggest not. And I suggest that this is a perfect case to show that 3 parents is not, or are not,
Well,
better
do we get
than
there? This
2.
is a standing issue, and this is an interpretation of a statute.
Yes.
So that may be true, but we have to get by the first issue. And we have to, as a court, decide what the statute says and whether we can interpret it at the plain meaning. And that's where I see my role.
I absolutely agree with the court that this is an issue primarily, perhaps exclusively, of statutory interpretation.
So your comment there was really affecting saying the equity should dictate and change the definition. And your argument here is, once again, going back to that, is that it's not whether 3 or 4 parents, because it could be multiple parents that could really help a child. But the fact of the matter is we're stuck with the word standing, we're stuck with the definition of either parent, and we're stuck with how do we interpret that.
That is correct, Your Honor. And if I just may expand briefly on the issue of 3 or more parents, what we have here is a third party who arrogated to herself the idea that she could take the child's state and federal tax returns. Not once, but for 3 years she did so. She's not required to pay child support. A non-parent is not required to pay child support in New York State.
Counsel, that argument is, I think that I believe the statute in the IRS code is that whoever the person resides with the most or the period of time. So I think that's just a wrong argument to go down.
Okay, fine, Your Honor. But
Is Mr. Ramos in this child's life?
Is he in this child's life? Yes, Your Honor. He was not in the child's life early on. He was not adjudicated the father, and he had little contact with the child early on. But he has had involvement since he admitted that he was the child's father.
Joint custody.
And he has joint custody, yes. And the difficulty that we have is not that things are just so swimmingly going on between these 3 adults. It would be nice if adults all acted like adults, but that there is this ongoing tension that they've been in court again, and again, to the point that that one of the parties has been held in contempt. And the sentence, as I recall, was a suspended jail sentence. So there's ongoing problems of...
Mr. Mulder, I'm sorry.
Yes.
Would you agree that the word either is a word of ordinary import?
Absolutely, Your Honor.
And under statute section 232, it says words of ordinary import used in a statute are to be given their usual and commonly understood meaning. You would agree with that?
Yes, Your Honor. I trust you're quoting McKinney statutes or Black's or Webster.
McKinney statutes.
Thank you, yes.
The law of New York. Thank you.
Yes, thank you. So that's the nub, that's the entirety of my argument. Thank you.
Thank you, Counsel. Thank you all.
Thank you.
1042, 1043, matter of Ramir D., Leonard D., Onondaga County DSS. People will clear it out. Good morning, Counsel.
Good morning. If it pleases the court, Rebecca Const, on behalf of the appellant.
Let me,
Nope.
interrupt you right away. How's that? It seems to me you got a little problem here because both in appeal number 1 and appeal number 2, they're both defaults. However, there was a footnote in another older Court of Appeals case that allows us to hear within a default matters of contest. And so I'm interested in this request that I think which was contested as I read it for this adjournment that was denied.
I mean, I would argue that there was an excuse. It was a reasonable excuse. Ms. Troutman would probably understand it. Ms. Whittenlow would understand it better than maybe the middle of the bench. The mother had called her attorney. She had explained what was going on. The attorney just didn't have time to get back to her and say, we need a note so that we can prove this excuse.
But
it
in
doesn't
this
seem like a delay
particular
tactic.
instance, we have to take the context that she gave this reason and her prior appearances or non-appearances, correct?
Correct.
And that's the problem?
It is an issue. In this case, we did have a mother who was getting frustrated with the process. You can see that throughout. She felt like she was doing what was being asked of her and she wasn't getting any progress. So I think in this case, the prior actions were a result of the frustration, and it was just circumstance that this happened this day.
And so, but the court had to use its discretion and consider conduct before, her reason that she gave at this particular point, the fact that it was scheduled for proceedings on that day, a day certain. The court had taken time to make sure everybody who was a relevant party was able to be present. And didn't she express at one point that she would not go forward?
She had made comments that she was done with the process, and like I said, that was indication of her frustration with the whole thing. She was doing the parenting classes, she was seeing her therapist, she was trying to do what everybody was asking her, and she was just very, very frustrated with
because
the situation.
the few times, I think either 2 or 3 times that she did appear, she suggested, and we're not going to hold her to that, but she did suggest that she didn't contest the permanency order.
And that's part of the issue, is the day of, there had been mixed signals and her attorney wasn't able to say definitively, yes, she wants this, or no, she doesn't want that. And I think that's the big issue here, is let it go back down, let's have the hearing, let's see what she's going to say with this. She wasn't given that definitive last step of saying, yes, I'm not going to contest this, or no, I do want to contest this. She was very frustrated with the situation.
Okay, thank you.
Thank you.
May it please the court, Joseph Marzaki on behalf of the Onondaga County Department of Social Services. Just as an initial matter, I just wanted to address appellant's contention that frustration on the part of the appellant should be a factor to consider for the court. I do struggle to see how that should be the case. Indeed, litigants are almost always frustrated with court, and in family court especially, when they deal with matters that are so close to their hearts. I'd also like to include, as Justice Troutman noted, that the court had an obligation to consider all relevant factors, including her non-appearance on 4 separate permanency hearing dates, as well as her volatile egress from court on a separate date as well. But the family court judge in this case explicitly noted when she was denying the adjournment request that she was considering the permanency of the child, and that permanency is a matter that should be handled expediently, and that if a parent refuses to cooperate with the courts or with DSS, the court has to consider permanency and continue to have these hearings so that permanency can be achieved. That's just something I'd like to point out. As to the matter of concurrent planning as well, I think there's a clear carve-out in the Family Court Act, specifically Section 0189D24, and that clearly authorized the court to plan for another sort of permanency arrangement if permanency with the parent is not practical.
Thank you,
if Your Honors have any other questions. Thank you.
Good morning, may it please the court. To Justice Carney's point about there being a footnote that allows the matter to be reviewed if there's a contest, we don't believe there's a contest here.
Yeah, the only thing I was speaking of is the one contested matter, that being the request for the adjournment.
Right.
I know it's, when I read the transcript, it's arguable that maybe, I understand your point,
Right.
that maybe that wasn't contested. So.
Right, and whether there's a legitimate request for an adjournment, I'd say if your liberty of your child and getting your child back is on for the calendar that day, you're going to make it, no matter whether it's severe or heavy or otherwise. That said, I think the points have been argued pretty well. If the court is interested, Ramir has had perfect attendance in his last school year and this school year so far. Mom is, I believe, relatively homeless. She's in a homeless shelter, but the grandparents have been allowing some contact. So he's doing very well and he's stable. And next month, it'll be 3 years that he's been out of his mother's care. So we think there are extraordinary circumstances here.
Thank you, Counsel.
Thank you.
1045 Brady, Contangelo. Good morning.
Good morning, Your Honor. May it please the court, my name is Kerry Byard, here for the plaintiff's Brady. The court had already decided that the jury was not to consider whether the movement of the leashes was negligent, be it caused by the defendant, his dogs, or a combination of the two.
Let me ask you this. This is a tough case. If there weren't some problems or some issues you've got to confront in the prior case. In the prior case in your brief, you said that any contact with the leashes occurred after the defendant came in contact with the plaintiff. The leashes are no more relevant than whether plaintiff struck a stump, a branch after being run into by the defendant. And what we did is we allowed the one claim to go forward, body-to-body contact. And so, based upon that prior concession, or at least as I read your brief, because I was on that prior case, I didn't think the issue was whether the leash with this individual holding the leash was the issue, because it was the colliding, and then the leash just happened to be there. You could have tripped over a park bench, for that matter. And now you're suggesting that the court erred when that cause of action was tried, because they should have considered the leash, at least from a perspective, I guess, that maybe the individual could have let it go, and then he wouldn't have been pulled into the plaintiff.
Your Honor, I don't believe that that section of a prior brief that you read is concession at all. I think
that's what I considered when I voted on the last case to preserve or to allow the one cause of action to go forward.
Well, Your Honor, the first cause of action has always, did then, does now, include claims of negligent handling of the leashes. Those have never been conceded.
Well, let me say, here we have the decision. We agree with the defendant, however, that the court erred in denying that part of his motion, blah, blah, blah. And it goes on to talk about the second cause of action based upon his alleged negligent handling of the dogs. Now, it seems to me negligent handling of the dogs would encompass the leash, no?
No, Your Honor, not at all. And let's go back to Dorr. I think we need to acknowledge that this is a pretty unique case in the realm of dog law. And it actually puts us squarely within a major trap that multiple judges on that Dorr case were screaming about as a potential problem here, which is when Dorr was decided in 2015, it eliminated this long line of cases about negligent handling of a dog that the appellate divisions had created. 4 of the 7 justices wrote that majority ruling. It's 3 paragraphs long, and it defines negligent handling of a dog as negligence claims when the injuries are caused by the dog. And that's only cases where it's the dog's volitional conduct that actually causes the injuries.
Okay, so let's assume that my reading of what took place before is incorrect. Get right into it. Tell us why.
Sure.
Why this was relevant, why it was an error.
Sure.
And really, I guess, what the theory is.
Yeah. Your Honor, the theory was, and the proof at trial was, the defendant himself was in control of these leashes the whole time. He was controlling their movement. He was controlling their placement. That was his testimony. Said throughout the entire incident, he was in control of the leashes.
He was walking the dogs weren't walking.
Exactly right. We have a direct admission, I think it's page 152 of the record, where he says the dogs were not pulling me around. So at the very least, we had a question of fact as to whether or not the placement of the leashes contacting Mrs. Brady was because of the defendant's actions or because of the dog.
In other words, he could have let go of it perhaps, maybe that's one idea, and the jury should have been able to consider it.
They should have been allowed to consider, of course. I mean, we're dealing with a factual scenario here where the path itself is about 10 feet wide. The plaintiff's another 1.5 or 2 or 3 feet off of the path. So what was the defendant doing all the way over to begin with?
Tell me how the proof came in at trial relative to, what came first. In other words, the bumping, the entanglement, briefly.
There was a dispute, Your Honor, as to what the order was. There was a concession and an agreement of the parties that both bodies and leashes collided. The plaintiff's version of the testimony was that the defendant ran into her, knocked her over the leashes he was holding in her hand. The plaintiff attributed the fall to a combination of the two, the bumping and the leashes. The defendant's version was the leashes touched first, caused her to start falling, and then he grabbed her to try and set her on the ground.
Your argument is that it was the defendant's body, it was his control of his body that caused her to be harmed. He happened to be holding the leashes. You're not saying the dog caused him, it was his bumping her, and that catapulted her into the circumstances that caused her to fall?
Yes, Judge. It was his control of his body at the time. And I think, to Justice Carney's point, there was this language in this court's prior decision that the definition of negligence in this case is whether or not the defendant failed to reasonably control his speed and movement in the vicinity of the plaintiff. And to your point, Judge, the fact that he's holding these leashes while he's controlling his speed and movement in that vicinity is relevant to his actions, not the dog.
And you would argue it's not an in-run around the other case law that says negligent handling because the dogs were still attached to said leashes?
We had I shouldn't say a concession, but there was an agreement of the parties here. The dogs didn't cause this injury. And that's the legal distinction from Dorr.
And that's where I struggle with that, is because it seems to me at best you got maybe a combination of both. Your client's testimony is that within seconds the defendant darted towards her, these two dogs before she knew he bumped into her. The leashes went around her lower leg and she went over the leashes and fell to the ground to her knees.
Yes, Judge.
So, it's now we're, you can see where the struggling we have here is that the negligence of the handling of the leashes, is it the defendant just bumping into her, coupled with the fact that the leashes wrapped around her?
Under Dorr, Judge, he can be liable even if it's just his handling of the leashes. And that goes to Justice Abdus-Salam's concurring opinion.
Yeah, and that's why in my mind, and I know you say your theory and claim is preserved or still, and that it's larger than how I framed it. But in my mind, if I read your brief and what we did in the last case, the way I interpret it, the problem you have is I can break it down to before and after. In other words, if you're suggesting in the brief that the leash was no more relevant than whether she struck a stump after the collision or tripped over something, anything, then in my mind, what took place before the contact is no longer in the case.
Well, let me put it to you this way, Judge. Even, let's assume a scenario where the jury was going to consider only the defendant's version of what happened, that the leashes began this whole scenario, that the leashes came into contact first and caused her to fall over. Let's take that. If the leashes contacted her first because of the defendant's actions, he can still be held liable.
Yeah, I don't know. That's the more difficult question, and that's I understand what your position on that is.
And that goes to Dorr. It's an inanimate object. It's going to control the law of gravity, which is what Abdus-Salam was talking about here, based on the control from the defendant himself. If we allow Judge Sentra, and I think even Justice Bonello down at the trial level struggled with this idea, it's a dog leash, right? There's a dog at the other end. There's this case from the Court of Appeals that says no negligent handling of a dog claim.
And
We have
there's
to
a person
acknowledge
on the
that.
other end of the leash.
And there's exactly right. There's a
Yeah.
person on
Yeah,
the
we
other
get
end
it.
of the leash.
We've
And a
given this some
jury.
deep thought. This is a.
But it's
tough one.
dangerous, Judge. And it's not just Abdus-Salam. It was 6 of the 7. It was Abdus-Salam, Reed, and Stein joining together in that concurring opinion, Littman writing his own concurring opinion, and then Justices Fahey and Piggott writing the dissenting opinion. 6 of the 7 screamed from the rafters that we need to be careful with this interpretation of Dorr, because if we let this expand to protect defendants from the consequences of their own actions, just because they might be handling a dog, in a colloquial sense, then we are expanding out and eliminating proper claims of negligence across this state. I get that this is a unique case. I get that it's tough that there are dogs here.
I'm sorry, do you agree that the leashes are irrelevant to our analysis?
I don't believe they're irrelevant to an analysis only.
Let me slow you down then.
Sure.
If the answer is no, in your brief in the last appeal, you said that the injury was caused by the defendant and not the animal.
Yeah.
Any contact with the leashes occurred after the defendant came into contact with the plaintiff. The leashes are not any more relevant than whether plaintiff struck a stump, a branch, or any other object after being run into by the defendant. That's the claim that we saved according to our decision. We gave you what you wanted there. So the leashes have to be irrelevant to our analysis if we stick with that, right?
I would disagree with that interpretation of our prior brief. And what I would say
I'm quoting
is,
from it.
I disagree with, yes, to the extent that any movement of those leashes, we can focus entirely on the defendant's actions. And that's what we should.
You can disagree with what we did, but I was on that panel and I know what I did. That's so. Are you familiar with this Scavetta case? I don't know if I got it. Sometimes I can't recall if I got it out of your brief or I found it myself.
I'm familiar with Scavetta.
Yeah, did you cite to that?
I believe I did cite to Scavetta.
Okay, that's an interesting case. That's the case where there was no cause of action. This is a second department case.
This is the Rocket Dog case in Manhattan, right?
No, it's a second department case, so it wouldn't be Manhattan, but I don't know exactly where it took place, maybe Brooklyn. But there was no cause of action with the dog owner. Maybe it's a first department case. Maybe you're right. But where the dog owner tied the dog leash to an unsecured bike rack, and the dog ran away with the bike rack and struck the plaintiff. And they found there that there was no cause of action.
That's right.
And that's, I know it's not quite on point, but probably doesn't help you, but.
Yeah, I'd like to touch on 2 things about the Scavetta case. First, to the point I think you're trying to make here, it was a bike rack attached to the other end of that leash, not a human.
Yeah.
It wasn't the defendant. In the event that in the Scavetta case, it was actually the defendant running around downtown Manhattan, running into people and knocking them over the leash, I'd be arguing that that's an applicable case here, because the defendant's action was moving that inanimate object. But what I also like to point out, that Scavetta case screams from the rafters that we need to be careful about the interpretation of Dorr. If I remember correctly, the department in that case was actively advocating for the overturning of the Dorr decision because the interpretation would protect defendants that should not be protected from the consequences of their own actions. And that's what we have here. We have a defendant here who says, I'm in complete control of these leashes the whole time. Dogs didn't go anywhere I didn't want them to go. And that leash wouldn't go anywhere I didn't want them to go. And it was for the jury to decide whether or not the movement of the leashes was controlled by the defendant, the dogs, or a combination of the two.
Yeah, I thought of an analogy, but if you're walking down the street, you're walking with your dog, and the dog jumps up on it, and you're on a leash, and the dog jumps on an individual, they fall and they get injured. And the argument could be made, well, if you had control of the dog on the leash, you would have pulled the dog back before it leaped on the individual, and therefore the individual wouldn't fall, and then we'd have, what would you have there, negligent control or leash here?
Your Honor, that is a case where the injury was caused by the volitional conduct of the dog. You're talking about the dog actually doing a thing, and that's what Judge Abdus-Salam, Reed, and Stein were talking about.
The only way the dog leashes got around the woman's leg or behind the leg is by the dogs.
No, not true. It's because of a combination of either the dog's movements or the defendant's movements. The defendant was over there, he walked him, he moved it, it's in his hands. Again, in a case where if the dog...
You realize that your theory that to pull the dog back in your case, that's a handling case, but you're
oh yeah, that would be a handling case,
we get it. We understand.
All right, and just, putting aside for a second whether or not we could make these claims, I do want to touch on our third point here, which was even if
we couldn't make a claim for the negligent handling of the leash. Proof regarding the leashes was relevant to the happening of the accident and the defendant's credibility. We brought in the physical leashes themselves. The doctor testified regarding the movement of the leashes for the mechanism of injury. So even if we couldn't make a claim for the negligent handling of the leashes, the modified instruction took away any consideration of the leashes, which would go to other relevant issues in the case. So either way, facts that were relevant for the jury were taken out of their consideration, and we didn't get a fair shake here.
Thank you.
Thank you.
Good morning.
Good morning. Please the court, my name is Dan Stracone from Chelsea's Expire Monte, here for the respondent Timothy Contangela. So two important things to touch on here. First, Justice Carney, I agree with your point. You've all echoed this, that the leashes are not relevant in this analysis. Whether it's my client or the dogs or in control, really isn't what we're getting at here. The question is who caused it. Jury decided this, they understood. This is why the modified negligence charge.
So it's not relevant if the defendant, using his own body, had contact with the plaintiff, and he then caused her, not the dogs, to fall and be entangled to suffer the injury alleged here.
That is relevant, Your Honor. My point is that it's not relevant who was in control of the leashes. However, yes, as you suggested, if my client did physically make contact with the plaintiff, that could be an issue. But that is not what had occurred at trial. That's not what we're discussing today. The control of the leashes, again, at this point, really is not relevant. And I'd like to clarify in the record.
Not the control, but that not the control of the leashes as it relates to the dogs. Are you arguing you can't separate negligent handling because the leashes in this instance were in fact attached to a dog? That it's just another way of saying negligent handling of dog?
No, that's not what I'm arguing. Simply that, pardon me, you said, am I arguing that we cannot separate?
Yes.
Oh, no, I think they're separate things, and I don't think it's really relevant of what the dogs.
But what I also ask you is, are you suggesting that plaintiff is still an in-run around the negligent handling of a dog by bringing the leashes back in? He is still putting forth that it was the negligent handling by the defendant that caused the plaintiff to fall.
Oh, yes, I understand. Well, I don't think that's appropriate. I think New York law makes it clear that there is no cause of action for something like this, which is why, and I think at the trial court, it was made, this was the main issue here. It's not whether the leashes were negligently handled. It was whether my client physically made contact with the plaintiff, because that is what she testified caused her injuries. So, as discussed earlier, if we say that that's not what we're talking about now, we're talking about negligent handling, that's simply not the claim.
Yeah, but is your rationale because it was somewhat limited by the arguments that were made in the plaintiff's brief on the prior appeal?
Agreed.
Or are you saying that if that didn't take place, we still wouldn't get there?
Well,
both,
yes.
You wouldn't break it down to the distinction between whether the dog was walking the individual, or whether the individual was walking the dog, and he could have done something, he could have let go of the leash, I guess.
I think we could focus on either of those moments, and either way.
Isn't there a difference?
Correct.
Okay.
I think you look at the past, what you discussed earlier was clear, and even now, no difference. So when it comes to control, and this is my big issue as we had just heard discussed, Appellant's counsel has cited to 3 moments in the record where control was discussed. Well, really only 2 of those 3 moments control was discussed. First, when my client was running in the park by himself before the encounter, he said, yes, I controlled the time. Later on, as he was approaching the plaintiff, yes, I controlled the time. Both those moments, of course he did, no reason not to. However, in the moments leading up to and during the 2 parties' encounter, he did not say he had control. Page 181 of the record makes it clear. He was asked, were the leashes taut? My client said, I was trying to as best I could. So to quote, I was trying to take control, trying to have control, he said. Of course, this does not mean that he had control, quite the opposite. So to say that he had control at the time is... So
your point is you can break it down to 2 things. In other words, the real act, if anything, the best case scenario for the plaintiff is that what took place after the body-to-body contact was caused by the dog.
Pardon me, you're asking, would that be...
In other words, after the body-to-body contact, That's the theory, right? They collided.
Yes.
You know, the two individuals I'm talking about. That anything that took place after that related to the leash that may have caused this was controlled by the dog.
Absolutely.
And therefore was a dog. That part of the case has been dismissed.
Correct.
Okay.
And that's where I think, okay, thank you.
Okay.
All right.
Thank you, Counsel.
1046, option 1, Kathy Brunner.
Good morning, Your Honor.
Oh, excuse me a second. Good morning, Counselor.
Good morning, Your Honor. If it pleases the court, Keisha Williams for the appellants. The issue in this appeal is whether the lower court abused its discretion in denying the appellant's motion to vacate its prior order. In 2006, respondent.
Yeah, you know, we're familiar with the facts, and they're very complicated. I was not on the prior appeal, but I do have a couple questions that may assist you a little bit. I understand your argument that it probably wasn't right. We'll get into I'll get into the law in a second. It wasn't right for, at the time that this discontinuance motion was granted, that contained within there was also a clause that voided out the acceleration. And the reason for that is there is case law that you've cited to that says that can't do that after 6 years, because then it's too late, right?
Yeah.
And therefore, if you can't void it out, and if you couldn't have voided it out, and the court shouldn't have done that, therefore, the time has come and gone, and you've got a valid statute of limitations defense. Right?
Exactly, Your Honor.
Yeah, and the problem with it is by not answering to the discontinuance, and I'm somewhat, a little bit sympathetic because I get it. Somebody says, hey, we're going to discontinue an action. You say, great, and then maybe you don't follow through with it. Maybe you're unrepresented. And so there, the problem, though, that we have is that it probably, you can't get to it now because the time is in. Maybe you could have gotten to it within a year, under that provision of 50-15. And so you want us to vacate it under two theories. One is subject matter jurisdiction. As I understand the arguments in your brief, you're saying that when the court did that, they went too far.
Exactly.
And you're trying to suggest that's subject matter jurisdiction. And that secondly, it's somehow some type of misrepresentation because, it couldn't have been done and it shouldn't have been done. And even though your clients weren't defending at the time, they were in default with that motion, that the court went a bit too far and the attorneys that asked for that relief shouldn't have, and it's just not right.
Exactly, Your Honor.
Yeah.
Also, under 50-15, the court has within its discretion to vacate its prior order in the interest of justice.
Yeah.
It's pretty clear from the record that when the court granted that discontinuance order, the respondent did not present any extrinsic evidence to prove that the statute had not in fact expired. The only thing that we
I
can
know
see...
there was an argument to be made that, look, even if we took it on, there was some tolling because of this bankruptcy, but I'm not so sure that's applicable because the 3 or 4 bankruptcies that were filed, there was also a lift of the stay.
Exactly.
And you wouldn't get the benefit of those days to toll the statute.
Exactly.
And you're saying even with that, it would be more than 6 years.
Exactly,
Yeah.
Your Honor. So the appellant's argument is that in granting that 2015 discontinuance order, the court abused its discretion then, and also abused its discretion when it denied the defendant's appellant's motion to vacate the order. If the reasoning that was given by the court that more than a year has passed and so the appellant cannot move to vacate is accepted, then that would render all the other reasons why someone could move to vacate under 50-15, because I
think the problem you have is that at least one of the problems on the motion to vacate, isn't it, they were actually served, right? On the 2016 motion, they were served.
On the 2015, the motion to discontinue, yes, the appellants were served.
They were served, so I mean, and then you want us, you're asking the court to open up the judgment in which they were served upon.
Because it was a default
Exactly. I mean, but you have
judgment.
to, what was the reason why they didn't respond?
I believe they were not represented, and so they didn't, I assume that they didn't understand what the consequences would be.
Ms. Williams, I'm assuming that this mortgage foreclosure case has continued. What's the status now? Is it moot?
I believe the property was sold, but the appellants, I did file on behalf of the appellants a lis pendens to give any purchaser notice that this action was still proceeding. I also made a motion to, in the lower court for a stay, which was denied.
What would happen now if we granted the relief?
I think that the appellants would still have the benefit of moving in the 2016 case to have that judgment vacated based on this. If this court were to grant a dismissal of the 2006 action with prejudice.
Was that before us?
Yes, Your Honor. The
2016.
The 2006 action. This is the 2006 action.
But
2016
we would allow you to
action.
vacate the default. Is that what you're asking us to do?
To vacate the 2006 action with prejudice.
The discontinuance?
The action entirely.
Yeah, but let me say one thing. You had mentioned about this 1 year, and under 5015A1 with reasonable excuse and meritorious defense, that's limited to 1 year. The other grounds are not. So.
There is no limit on the other grounds, Your Honor.
Right, yeah. You understand that?
Yes, sir.
Yeah,
Yes,
okay.
and that's what I argued, that there is no limit under the other grounds. I would
right,
also.
But my point was that if you were able to make it within the year, maybe you might have a little better argument, because I'm having a hard time getting to. I don't think it's a subject matter issue, and under the other grounds that you brought it on.
I think that there is case law that says that the court cannot expand the statute of limitations, which is what the court did in this case. And so I would argue that that was outside of the court's jurisdiction to do that. I would also like to point out that although the respondent argues that there were payments made up until the 2008 bankruptcy was dismissed. In the 2016 action, there the respondent claimed that he
went back to 07.
Yes, the defendants.
Said the default was in 07, which
Exactly.
that can't be, because even if they were successful, you can only go back to 2010.
Exactly, Your Honor.
To 6 years.
So
Yeah,
now
we're
take
we're cognizant of that.
Okay, thank you.
Good morning again.
Good morning again, Your Honors. May it please the Court, John Sarando, on behalf of Option 1 of acting of counsel to find such and Crane. I think the overriding umbrella here, or tent, is that the defendant defaulted in the foreclosure action. And insofar as the statute of limitations is concerned, and I think today's the day of prior decisions, because in the subsequent action that was commenced in Supreme Court, this action being in county court, at 160 AD 3D 1473, on the panel at the time were Justice Sentra and Justice Winslow, they affirmed the amended order granting plaintiff's motion for summary judgment in that case. And it's my understanding that one of the issues raised in that case was the statute of limitations defense.
Yeah, so they're just left with trying to vacate this under the grounds that were laid out accordingly. You know, they may have had an argument when the motion for discontinuance was made that, hey, look, you can't void out the acceleration because the statute has come and gone. But your point is, so is the right to appeal from that.
Yes.
It's come and gone.
Yes, yes. And when you look at the county court's decision and order, it's unbelievably thorough and covers every aspect of the claims of the defendant, and we submit that the order should be affirmed.
Thank you, Counsel.
Unless there's no other questions.
1047 Davis v. City of Buffalo, ZBA.
Good morning. May it please the court. I would first like to deal with the issue of mootness, and I think that the Dreikhausen case, where Chief Judge Kaye indicated when the mootness doctrine would apply, is significant to the claim of mootness in this case. Judge Kaye indicated that the most important thing in determining whether a matter is moot is whether the petitioner had applied for some kind of preliminary relief. In this case, the petitioners applied for a temporary restraining order by order to show cause in front of Justice Walker at the trial level, and also applied for both a preliminary injunction and TRO in this court, where the order to show cause
was denied by Justice Kern. Let's just get into the meat of the argument. Let's just get into the meat of the argument right now, okay?
Okay.
Really, the first issue you bring up or you address is whether or not ZBA complied with state and local laws granting the 8 variances.
Yes.
And you march through a number of problems that you have with that, publications and sufficient notification and descriptions. Why don't you discuss that issue?
Yes. Well, the major part of that issue I would like to discuss, some of those I'll leave to my brief, so I'll have enough time, is the requirements of the general city law, Section 81B4, which requires a zoning board to consider various aspects of a project when determining whether or not to grant a variance or not.
Yeah, the 5-factor test.
Pardon me?
The 5-factor test.
Yes, 5 factors that should be considered. And once they have determined to grant or deny a variance, they're also supposed to supply the reasoning behind their decisions. In this case, first of all, they granted 8 variances from the Uniform Development Ordinance, what's colloquially called the Green Code, which was approved by the city on December 27, 2016. They approved these 8 variances from the newly adopted code on July 1917. So even though after a rigorous work on developing this new code, the Zoning Board of Appeals granted 8 variances, and some of the major variances, in fact, they did indicate that the variances were substantial.
But they made findings on that, right? Is your argument that they didn't reduce it to writing, or is your argument is that they were wrong?
Well, that they were arbitrary and capricious, yes.
Okay.
That is my argument.
I mean, in essence, you disagreed with what their conclusions were.
No, I don't just disagree, Your Honor.
Well, you're finding them arbitrary and capricious. You're arguing that argument, saying that it doesn't comply with that. I mean, that's what the arbitrary and capricious standard we're dealing with. So the way I read it and look at it is you didn't like or agree with ultimately what their determination was.
When the resolution was adopted by the Zoning Board of Appeals, the only reasoning they gave was repeating the 5 factors. For example, they said there won't be any undesirable change in the character of the neighborhood.
Yeah, your point is this, is that, in other words, you've got to consider the 5 factors. You understand that, you know, our review is limited to various things, illegal, arbitrary, and capricious. And you're saying you just can't recite the 5 factors in the statute. You got to go through them. You got to say this factor, and then you got to apply the facts of this particular case to the factor. You just can't jump right to the conclusion.
That's exactly right.
Your point is because they didn't do it the proper way, it's arbitrary and capricious, and that gets you there.
Yes, and incredibly, they didn't even mention in the resolution the effects on the historic properties, which was the major reason this case was brought in the first place. They didn't even mention it. Not until we filed our lawsuit or our petition did they then, apparently realizing after reading it that they may not have provided the appropriate reasoning, only then did they then come up with reasons. And clearly any reasoning at that point was just an ex post facto rationalization. And as I say, I'll leave the other issues to my brief as it relates to the ZBA. Now, as to the planning board, this type 1 action, where an environmental impact statement was in fact done, first of all, they did not inform the Preservation Board of the City of Buffalo of the seeker review proceedings, and they did not reference them with any of the seeker documents. Now, the first line
They participated, didn't they? Did they get there?
Pardon me?
Did they participate?
They did not participate until later on, as I'll explain.
Okay.
The first line of defense was that this issue was raised the first time in appeal. We've shown in our reply brief that in our memorandum of law, we specifically raised this issue. So it's not the first time in appeal. Now, the City of Buffalo Historic Preservation Ordinances give specific responsibilities to the Preservation Board to review any application where the properties at issue that may be adversely affected are in fact either landmarks or within the preservation.
It appears from the look of this that the planning board did consider the State Historic Preservation Office's opinion.
Yeah, I did, and I'll get into that in a moment.
Okay. Well,
the first issue I'm dealing with is the Preservation Board.
With the City of Buffalo.
And the Preservation Board, pursuant to Section 103-6H of the city charter, also, whenever there's proposed demolitions of historic properties, and there were 12 homes.
Well, at this stage, the properties have been.
Pardon me?
At this stage, the properties have been knocked down.
Yes, the properties were still up. In fact, the Preservation Board, when they got the reference from the Commissioner of Inspections and Licenses, unanimously denied the demolition. So failing to notify the Preservation Board of the seeker process, of the seeker documents, so that they could have provided their expert input, is not inconsequential, which was the circumstance in the cases cited by the respondents in this case. Okay, then on the planning board issues itself, they did identify the historic properties as they must in their environmental review. They have to identify the environmental issues, take a hard look at them, I mean, you know this, and give a reasoned elaboration for their decisions. In this case, it is respectfully submitted that while they did, in fact, identify the issue of the demolition of the homes and the effect on this monolithic 4-story apartment building on the other historic resources. The fact is that in giving their reasoning, the standards on which they based the reasoning was arbitrary and capricious and really illegal. For example, and as you know, they received a letter from SHPO specifically indicating that they felt a hard look had not been taken on the historic resources, and specifically indicating that there will be significant adverse effects.
But there's no doubt they received a letter from SHPO, but they disagreed with it.
Yes, SHPO is not binding on them because there's no state action here.
And
However,
they received it, they considered it, and they disagreed with it.
It is very common for municipal lead agencies to supply the DEC, or when there's historic resources involved, the State Historic Preservation Office, with a reference. And often there are no historic resources that are being impacted, which is one of the reasons they do it. But it's very common for them to do that. And the importance of this case in terms of public policy is what is the interplay between the historic preservation laws in New York State and the State Environmental Quality Review Act, and what is the responsibilities of a local lead agency when they receive an expert report from the State Historic Preservation Office. Now, getting into the reasons that they gave, these 12 houses were considered relatively shortly before this project was proposed to be contributing buildings to the historic district.
Well, it wasn't the building itself, it was actually the configuration of the number of buildings. It wasn't that either one of them were historic, it was the fact that it's a historical area.
It's not any one landmark. It's the conglomeration of all the buildings. However, when the State Preservation Office and the National Park Service, which after a rigorous analysis determines whether or not to approve an historic district, they determine which buildings within the district are contributing to the historic nature of the district. And these 12 buildings were considered to be contributing.
Council, your time's almost about up, you got a minute left.
Pardon me?
Your time's almost about up, you have a minute left. Okay.
All right. They, to be contributing, but the planning board in their reasoning said they're not contributing because they...
So your point is that they couldn't ignore their significance.
It wasn't within their province.
They could say it didn't have an adverse effect on them.
Yeah, it wasn't within their province or jurisdiction to determine what's contributing or not contributing. They also, and the reasons they gave, they also said, well, there's a lot of other built houses that are similar to this one. Well, that's a slippery slope because we take some here, we take some there, and eventually what makes the architecture of the city of Buffalo so important and so unique to the residents and to preservation tourism will be lost. You can't, and so that reasoning, just because there are other homes similar, or just because, you know, we have this landmarks, this church that's a landmark, therefore we can tear down this other church that's a landmark because we have similar landmarks. That's not appropriate reasoning. That's arbitrary and capricious.
Okay, thank you, Council. Good morning.
Hello, Judge. May it please the court. I'm Steve Ricca from Bond, Chenick and King for Respondent Affinity Elmwood Gateway Properties LLC, the developer in this project. I know you're familiar with the voluminous record. I hope you'll agree that the public review process here was extensive and subject to the highest level of review under seeker. This is not your typical seeker case when you're asking yourselves why an environmental impact statement wasn't done. This is a case where an appellant is criticizing the nature and extent of that review. I'm going to skip over all of my procedural arguments on the ZBA determination. I think they're more than adequately briefed, other than to say that I disagree with the appellant's characterization of the general city law requirements. It does require a consideration of the 5 criteria for area variances, but it does not require findings on each and every one.
Yeah, you're saying that you don't have to write it out?
I'm saying that they have to be considered and balanced, and that the case law is consistent with the notion that if you look at the record as a whole.
How would we know? How would we know if they were considered and balanced if you didn't reduce it to writing? I think I wrote a decision as a trial judge on 267 of the town law. I don't have it in front of me, but is that a variance too, but it's just in the town law, do you know?
I think so.
Yeah. And I think that's what I did. I said, no, you can't backfill. You've got to lay it out in writing.
There is definitely support for that proposition.
How would we be able to review it?
By looking at the record as a whole.
Okay.
But however, as Mr. Lippis pointed out in his argument, there is a staff report in the record that has been characterized as an ex post facto determination. It's a convenient consolidation, however, of everything in the record.
Mm-hmm.
And if you look at the ultimate relief that appellants are seeking in this case, i.e. go back and do it right, it's really sort of a done deal already. It doesn't even, in the interest of judicial economy alone, I would suggest that it's really not something to which appellates are entitled and not something that's consistent with the case law.
Okay, what about his argument with the hard look? I guess, we all know what the standard is, and I guess whether the project has an adverse impact on the historic resources, and you provide a reasoned elaboration. So I think, if I understand his argument, he's saying that it wasn't, you didn't give the benefit that it's already been determined to be a historic resource and then consider what was adverse. You instead said it's not a historic resource, and that isn't the proper way to apply it, and therefore it's arbitrary and capricious.
Well, there's a number of components to your question. I'll deal with what might be a threshold question, historic resource. There's been discussion about resources that are contributing to a national registered district. What Mr. Lippis didn't mention is that there are thousands of contributing homes and structures within the Elmwood East Historic District. These are and were a handful of them. The fact that the city elected to involve the State Historic Preservation Office, which it had no legal requirement to do, doesn't obscure the fact that the City of Buffalo Planning Board did in fact consider the comments of the State Historic Preservation Office, which, by the way, my papers will show that those comments were solicited by prior counsel for the appellants. SHPO issued its usual letter saying, well, if there is state agency action, you may need to do X, Y, and Z. That wasn't satisfactory to the Arthur Giacalone, who was representing the appellants previously. He literally implored the State Historic Preservation Office to say something more. So the City of Buffalo took that letter in its entirety and incorporated it into a draft environmental impact statement. To the extent that there's any merit to the idea that SHPO thought that the City of Buffalo didn't look at that sufficiently, any doubt would be erased by the final environmental impact statement. You can't just look at comments on the draft environmental impact statement. That's what the secret process is all about. So in a meaningful way, not only were SHPO's comments incorporated in their entirety and addressed in detail, point by point by point, they were also addressed in a final seeker findings by the planning board as lead agency. That very detailed set of findings is incorporated by reference into the Zoning Board of Appeals seeker determination, as is typical, as is lawful, as is appropriate. So the suggestion that one way or another all of these factors were in part and parcel of both the planning board and zoning board determinations is contrary to the record. We think there's a more than ample basis in a number of ways, both explicitly and by incorporation, that the legal standard was met. Which I'm tempted now to just get right into the whole argument about the City of Buffalo Preservation Board. I've argued that this is not properly before the court. I would agree that in a memorandum of law that was added to the record via certification after the appellate rules were changed, This is something that got in without any involvement from counsel for respondents. Having said that, the memorandum of law mentions the allegation that the City of Buffalo Preservation Board wasn't notified, but it in no way gets into all of this stuff about the Preservation Code, Chapter 137, or the City of Buffalo Demolition Code, Chapter 103.
It was just a recitation of the facts. It wasn't a legal act.
Exactly, and I'm prepared to address those provisions and procedures in detail.
Usually we don't get this far. We don't know what the memorandum of law says.
Yeah, so, I mean, I guess what I would say is, to the extent that we have briefed established case law on the fact that SHPO, as an interested agency, is harmless error. If we didn't even notify SHPO, it would have been deemed harmless error under prevailing case law. The same holds true for the City of Buffalo Preservation Board. There's nothing in the record that shows that the City of Buffalo Preservation Board has jurisdiction to issue, approve, or deny the permits. Now, here's kind of a big picture characterization to help keep these things, I guess, in the appropriate categories. The Planning Board and the Zoning Board of Appeals of the City of Buffalo entertained a construction project, permits for that project, site plan review, area variances. That was something for which they were involved agencies. The seeker documents specifically identified them as such. All of the other agencies were identified as interested. With respect to the City of Buffalo Preservation Board, their jurisdiction works this way. You can only get a demolition permit if you first get site plan approval. There's a prohibition under the new zoning ordinance that Mr. Lippis referred to that prevents you from applying for a demolition permit until you get site plan approval. So in this case, from a 10,000-foot perspective, Affinity applied for the permits and received them. As soon as it did that, it applied for demolition permits, now that the prohibition was lifted. Mr. Lippis correctly points to Chapter 103-6H, which requires a referral to the Preservation Board. That was done. We don't dispute that. The City of Buffalo 103-6, in requiring a referral to the Preservation Board, also dovetails with a different City of Buffalo code, Chapter 337, a code that is not briefed or that does not appear anywhere in the 3,000-page record in this case. That chapter makes clear that the City of Buffalo Preservation Board has neither jurisdiction over demolition permits in a binding or anything other than an advisory role, nor does it, for that matter, have jurisdiction to issue final approval to designate something as a local landmark. We attached to our papers the Denman decision, a recent on-point decision which makes clear that the City of Buffalo Preservation Board has no jurisdiction unless there's a local landmark designation. You know, there's a conflation here in the papers on the part of appellants to equate local landmarks with National Register districts. That's been rejected. The Denman decision makes that perfectly clear. But even if you accepted for the moment that there was no actual notice to the City of Buffalo Preservation Board, what's also clear is that there was certainly constructive notice because Mr. Lippis was a member of the Preservation Board at the time that all of this was occurring. And I think, frankly, to the extent that you would even entertain arguments under Chapter 337, you should also consider that the appellants failed to exhaust administrative remedies. There was no designation petition to the City of Buffalo. At no time did the appellants or the City of Buffalo Preservation Board seek to have these properties, these buildings among thousands of buildings in the district designated. And the reason for that is they didn't have any individual historic significance within the standard.
As I mentioned earlier, we're dealing with is that the multiplicity of it is what contributed to any historical.
Exactly. So, you know, I would submit that it's not properly before the court. There's a failure to exhaust administrative remedies. There's a distortion and conflation of National Register districts with local landmark districts, which renders the argument utterly without merit. And that, on balance, the record more than provides a sufficient basis to uphold the determinations of the City of Buffalo Planning Board and Zoning Board of Appeals.
Thank you, Councilor. Good morning.
Good morning. May it please the court, Jessica Lazarin on behalf of the City of Buffalo. We're prepared to rest on our papers concerning the challenge to the determinations of the Planning Board and the Zoning Board. I just want to address the issue that Mr. Lippis raised when he started, and he let you know that he views this case as being vital to determining what is the role of SHPO, this state office, and what is their role as to the determinations that the City of Buffalo makes when they're looking at development projects that involve buildings that are on the National Register. And so I think that that is a real concern that we've seen from this petitioner, and I just want to address that briefly. It is our position, and we've maintained it, that SHPO is the New York State Office of Parks, Recreation, and Historic Preservation, and pursuant to their own regulations under 1409, their review applies to state agencies. The City of Buffalo is not a state agency. The City of Buffalo Zoning Board of Appeals, while we have permission from the state to have our ZBA, the ZBA is not a state agency. The City of Buffalo Planning Board is not a state agency. So it was the Planning Board as lead agency, it was in their discretion to advise SHPO of this development project.
And they did, and
they
SHPO
did.
responded, and they considered it, and they didn't agree with it.
Yes, Your Honor, and that is exactly my point. And I don't think that there is anything further required of the Planning Board, even though these buildings were on the National Register, because we're not state agencies, and we don't have to take our direction from SHPO.
Thank you very much. 1048 has been settled. 1049, Barrett Paving Materials versus New York State Thruway Authority.
You do like the second part, we all got it off, because we were number 4.
Good morning, Your
Yep,
Honors.
still morning. Good morning.
It is still morning, or at least 4 minutes. My name is Jen Harvey. I'm the attorney for the appellants here, who are a group of open shop contractors performing
It all
heavy
comes
highway
down to
work.
standing, correct?
All about the standing, all about how do you challenge
obviously
an
seen it.
illegal specification. That's really the focus here. And it's important to remember that this particular procurement is extremely unusual in its terms and in the way that it precludes a challenge from someone who submits a statement of qualifications or actually engages in the protest process. And that's what I wanted to talk about, just to ensure that the court didn't.
How does it preclude? Because you're relying on the Elia case, right?
I'm relying on the Elia case and the cases that have come after it, some of which talk about effective preclusion. In this particular case, the way that the procurement is structured creates an as-applied preclusion. And if you think about it that way, it makes perfect sense. A project labor agreement is something that is an agreement that an open shop contractor, especially on a project of this size and scope, can't exist with. Primarily because it requires...
Can't as a matter of law, or can't as practicality, or in what sense can't?
Can't as a matter of staying in business. The project labor agreement mandates that a majority of the workforce for the completing contractor come from the union halls. If you're an open shop contractor, you may have hundreds of workers, as do my clients here, that you would have to lay off and perform what was expected to be a 2-year job. When you get to the end of the job, those folks are not going to be there to come back to work for you. So you have this whole thing. The other component here is that as an open shop contractor, you are accustomed to dealing with your workforce. You know how to price that. You don't know how to price perhaps the union functions. The other facet here is that as a signatory to the PLA, you would be required to subcontract only with union subcontractors. Those would not necessarily, although they could be, some of the folks that you would typically subcontract with, but it would present some difficulties there as well.
How do you deal with the Lancaster case in the 3rd Department? And would we have to specifically disagree with it?
The Lancaster case, well, there were 2 Lancaster cases. I was involved with both of them. The first Lancaster case resulted in the PLA being deemed an inadequate savings. And what happened was the court determined that it was not properly founded. The procurement was canceled. The contractor who was actually performing it could not get paid, which is a problem with these kind of things. The Lancaster 2 case is what happened when the state rebid that same contract, or what was unperformed in that contract, and put a PLA on it again. The issues in Lancaster are markedly different than the issues here. Here we have a project labor agreement which was made a specification which had an anti-competitive effect immediately upon its advertisement. And in this case, we know based on the return that we've received here, that the study and the PLA itself, the PLA didn't exist at the time that it was mandated. So what you have is, a specification of unknown scope and quantity as part of a public work contract. The petitioners here asked questions during the procurement. They tried to avoid, quite hard to avoid a lawsuit. They asked very pointed questions as to what is the study? Can we please see a copy of the project labor agreement? And they were told no.
Well,
Study is
I
not
think
relevant.
maybe part of the core of Justice Kern's question was, in the Lancaster, they held that the voluntary decision to forego submitting a bid is, and in this case, they voluntarily chose not to submit a bid.
Well,
They participated in the protest process too, right?
yes. And here's the distinction and the difference. The difference is the very specific procurement language in this particular contract.
Yeah, because you say if you did submit to it, you'd be waiving.
You would have
your
waived.
rights.
We wouldn't be here.
And that's the distinction.
That is the distinction. So what was happening is the procurement built a better box. It built a box in which challenge was not going to be possible and was therefore futile. And that's why we're here talking about futility of the protest procedure. It must be noted that one of the appellants did attempt to engage in the protest procedure. The first step of the protest procedure, as called out in the procurement, is a mandatory request for an informal conference. One of the procurements did submit that request weeks before this case was due.
Yeah, but was that done procedurally proper, or was it?
It was
more-
procedurally
was it more
compliant with the
informal?
terms of the procurement. It was
Okay.
sent to both the counsel for the throughway and as well as the other designated person. If you look in the record, you will see that they recognized that they received it. They did not react to it. And you have to understand the other aspect here is due to the procurement lobbying law, you are extremely limited as a potential bidder in who you can talk to. You can only talk to the designated contact. In terms of a protest, you can only send a protest to the designated people. The communications are extremely directed and limited, with the idea that, it's going to be fair. I mean, because that's the ultimate underpinning of the competitive bidding statutes is more competition is better for taxpayers because it means lower prices. It also means inherent fairness. In this particular case, my folks who are all open shop contractors, the open shop contractors had performed 83% of this kind of work in the past. They didn't bid on this project. And they were carved off of it because of this particularized specification. I heard Justice Carney talking this morning about a decision being backfilled. That's what this was. This was a backfilled decision. A PLA determination is something that, according to the Thruway Authority case, has to have a more than rational basis because it's anti-competitive by its very terms. And if you read that case and you read Justice Smith's commentary there, you will see that it's recognized to be anti-competitive. There are other cases, which we've cited in our papers, which reference other types of anti-competitive specifications, many of which are, or at least one of which is subsequent to the adoption of local law, or of labor law, section 222, which does recite all of the purposes of the competitive bidding statute, which is protection of the public fisc, preclusion of impropriety, and other things. So that is intended to be the thing, is there should be this level playing field. But the issue is, if there's an illegal specification that by its nature prevents you from participating, from exhausting, where does that leave you? And where does that leave a challenger? In this case, it happens to be a PLA specification, but it could be another type of specification. And I do think that this case will have some wide-ranging effects.
Yeah, the reasons that you're competitive and to the benefit of the public are the same reasons you can't participate in this even from the point of submitting anything.
Right.
Yeah, we understand.
Well, and at that point, at the point at which you had to agree to abide by the PLA was undisclosed. No one knew what it was going to look like. And it wasn't even adopted and negotiated until long after it was imposed.
Is one of your arguments too that you'd have to falsely represent, you'd comply with the specs that you know you couldn't have?
Correct.
So, yeah.
This particular specification required that a bidder at the SOQ state of the procurement would agree that they were going to comply with all of the components of the procurement. So you're darned if you do and you're darned if you don't in this, and we're in the unfortunate position of having to argue futility, which I understand, I know is a difficult argument to make. However, the specifications here are unique, they're different. This is not the standard specification that one sees in state contracts. This is a unique specification, and it does seem kind of purpose-built to preclude protests and to preclude later challenges. Even if one were to protest, you would have to demonstrate a clear and convincing violation of law. You would have to agree to accept the decision of the Thruway Authority as final and binding, which, you apply the Tofano standard to it, that has some real meaning to it. That means that you don't get to come here and talk about the merits of the matter.
It doesn't preclude you from coming to court.
Well, yes, it does, because in this particular procurement, you have to indemnify the Thruway Authority its costs. I guess you would have to come to court. So let's say, for example, that our one appellant who tried the informal conference and didn't get a response, say he sued this instead. He would be in a situation where under the procurement, he might be asked to indemnify, if he had put a bid in and then sued this without engaging the protest process, he might be asked to indemnify the Thruway Authority's costs. There's some very unique and different features on this particular procurement, which are unfortunate in that they really don't get to the end analysis, which should have been, the way a project labor agreement should be applying the Thruway Authority case adopted is that there should be a study. The study will identify potential savings. Project labor agreement will be negotiated. The savings will be determined either to be achieved or not achieved, and then a determination is made whether or not to implement it. In this case, the determination was made way in advance of not only the execution of the agreement, which did not achieve all of the savings, but it occurred at a point where folks had to agree to a whole bunch of things that would have nullified any opportunity that they would have had to challenge.
Okay, thank you, Counsel.
Thank you.
Good afternoon.
Good afternoon. May it please the court, Allison Levine for respondents. The court should affirm here for either of two reasons. First, petitioners failed to exhaust their administrative remedies, and second, they lack standing. Because I think failure to exhaust is actually a little bit more straightforward, I'd like to start there. The procurement process here included a protest procedure. That procedure allowed firms to challenge the propriety of the PLA at issue here by filing a protest. Because petitioners, however, never filed a protest, they failed to exhaust their administrative remedies and judicial.
What about the one that did?
Well, I think that was intended to be what the provision says, informally discuss the nature and basis of the protest with the authorities. So I think it's unclear from the email whether or not, in fact, that was intended to be an informal protest. But let's say it was. Even if it was intended to be an informal protest, they nonetheless had to move on to the next step and actually file a written protest. That was merely the first step. They had to move on through.
It's a protest process.
It's a protest process. Yes, exactly, Your Honor. They had to move on through the process and even seek, an administrative appeal of any adverse decision if there was one. And I would point out that although counsel just stated that that there's a bar to come to court, the protest process specifically says that if after an administrative appeal the particular firm gets adverse decision, then judicial review is available. So there's no bar to judicial review in the protest process. And it's not just a mere omission here. they deprive the authority of an opportunity to rule on their challenges in the first instance, then they deprive this court and Supreme Court of a reasoned determination here. And their exhaustion, their argument that exhaustion was futile fails because even if they didn't receive a response, as I said, they still had to move on.
How about if we move to standing?
Yes.
Can you talk to me about the Lancaster 2 case?
Sure.
And isn't it an appropriate distinction to say that there was a PLA and the specifications there and there wasn't one here? Is that a true distinction and does it matter?
Lancaster involved a PLA. Both cases involved a PLA. Lancaster is directly on point here.
There was no PLA in the specifications here, was there, when it was first?
There was no PLA there was the agency had not yet adopted a PLA. It was negotiations were beginning and then during the process they were ongoing, but petitioners didn't need the express terms of the PLA to challenge it here.
But was there one in Lancaster? It seems like there was based on the decision. And is that a distinction that makes a difference?
Yes, there was a PLA here and there's a PLA in Lancaster. They're remarkably similar cases. They're brought by the same law firm. In both cases, they're pre-bid challenges where a PLA was at issue. In both cases, the particular contractors failed to submit. In Lancaster, it was a bid. Here, it's even further removed, right? These aren't even, we're not even talking about non-bidders here, Your Honor. These firms are not just non-bidders. They're not even qualified. They haven't even established that they're qualified to bid. They're even further away from the Lancaster plaintiffs because they haven't submitted statements of qualification. So there's nothing that the Thruway could have done here to assess whether they were.
What about their argument that if they did do that, they would have waived their right to challenge the process?
Again, that's because they're also refusing to avail themselves of the protest procedure. If they had filed a statement.
Getting back to your administrative remedy.
Yes, that's exactly right. If they had filed, what they could have done here is they could have filed a statement of qualifications and then also submitted a protest, and they could have moved forward with the process. And their claim that the PLA was illegal here, that's a very, that's an alleged injury, but it's a very speculative alleged injury. They're basically saying that any bid we put forward could not possibly be competitive here. Well, you didn't put a bid forward, so we don't know how competitive it could possibly be. And what we do know is that an open shop contractor made it to the short list. So it is possible that an open shop contractor could be competitive.
Your point is you can't sit back and do absolutely nothing.
That's exactly right, Your Honor. You have to put your hat in the ring. And that makes perfect sense here. If a contractor is going to try to hold up an entire procurement process, that contractor has to at least have a stake in the process. Petitioners have no stake in this process. And I would just mention, too, that any alleged injury here is outside the zone of interest as well because they're not protected by the competitive bidding laws, again, because they didn't bid. And those bidding laws are intended to protect the public fisc, not people that are complete outsiders to the bidding process.
Thank you, Counsel. 1050 Knapp v. Finger Lakes, New York, Inc. That's right. Oh, that's right. Okay, yeah. Justice Winslow's recused. All right. I'm not going to let him use it. Good afternoon.
Good afternoon. I'd like to thank the court for taking the time to hear my petition. I'm not an attorney, but a CPA, and with my wife, I'm one of the plaintiffs in this matter. Throughout my whole life, I've been a strong believer in our laws, our system of justice. Those beliefs have been tested during this case as the laws and the undisputed evidence have been ignored, and we, my wife and I, have been denied our legal property. Article 3A of the lien law is very prescriptive in defining just how trust funds should be handled, the purposes for which those trust funds can be used, and how the trustee needs to account for those trust funds.
Yeah, I guess the real question is how we address that in relation to a breach of contract case. And I'll try to break it down for you. Are you following me?
Yes.
Yeah. In other words, your measure of damages from the breach of contract. versus what the measure of damages are with a trust.
Correct. And there's a lot of evidence that supports both damage amounts.
Right. In other words, your argument is that you could obtain damages from both, and they're not a duplication of the damages.
Correct. And there's plenty of case law that supports that.
Yeah.
And you're arguing that the lien law recovery is for a different purpose?
Yes. The purpose of the damages, and I mean, the damages themselves were significant. In January, this is table, if the court please.
In other words, pursuant to our court rules, without prior permission, you're not allowed to use any exhibits, and our rules are published on the internet.
Okay.
So,
what I'm referring to is the table that's presented on pages 27 and 28.
Yeah, and I don't have the record right in front of me right now, but are these the damages that flow from the violation of the lien law or from the breach of contract?
So this is the violation of the lien law, which occurred long before any supposed
so we understand. We understand that if you don't put the money in a separate account and then pay it out accordingly, it's designed. You know, there's a law that says it's designed to protect subcontractors, but it's also to design folks like you and your wife.
Yes,
we understand
the
that.
1987 amendments were specifically to add additional protection for homeowners, and there, you know, I think the Attorney General Abrams and Senator Kehoe at the time, you know, highlighted those.
And so your argument, I guess, if I understand it, is that you should be able to recover for those damages as well as damages for the breach of contract, and those are not a duplication of damages.
Correct.
Because you went out and had somebody else finish the house, is that my understanding?
Well, there were, if the court pleases, that there were multiple issues that were going on simultaneously.
yeah, but I think, as Justice Carney's pointed out, you know, it's a two-facet case. We have a breach of contract, you paid money, what you received, and what you had to pay to complete the contract, as opposed to what the court previously determined a violation of the lien law, the trust funds not being put in there, and that in and of itself, what damages flow from that. For instance, if 6 months had gone by before he utilized that money on your project, there's damages that you incur. You may have incurred, you know, you may be entitled to the interest of the money. You may be entitled to his use of your money for 6 months at statutory interest.
Well, part of the issue with this is that the contractor purposely hid our requirements under the lien law. The contract itself was required under Article 36A to define 8 required elements. 3 of those 8 were purposely omitted that defined our rights, our right to our money being placed in escrow.
Yeah, in other words, so as Justice Centris said, your point is that if the money was diverted, okay, in violation of all these requirements, that you'd be entitled to damage for that. You'd also be entitled to damage for interest on that money, and even attorney's fees to prosecute that particular part of your claim.
Correct.
And then
That is
in
allowable under
addition,
the
your
law.
position is you'd also be able to recover for breach of contract. And I think the point here is, as Justice Centris said, is the difference between, you know, what the contract price was and what it cost you to finish it.
So in rough numbers, we paid the initial contractor, Finger Lakes, and the owner, defendant.
But you recovered for the breach of contract?
We have not been paid anything on the breach of contract.
But you were, I mean, you didn't get paid, but you were.
Not be paid. Finger Lakes, New York was really a shell company that our money was not even deposited into Finger
We
Lakes.
recognize, I think what the question is this, that the jury came back with a verdict regarding just the breach of contract. So there was a sum certain that was given, you haven't received it, but awarded in your favor against the defendant.
Correct.
And so
we had provided the jury
understand.
with evidence showing that we had incurred $115,000 of costs outside of the contract to repair those damages. There was another $12,000 of costs that we had quotes for that we hadn't yet incurred, and then there were 3 other items that we had not.
And you recovered for that? I mean, you didn't get paid,
And
but the
we
jury.
recovered. Those costs would never have been incurred by us if the work had been done properly initially.
Yeah, we understand that. And
by the
so-
contract.
But you're really here about your second claim. You're saying, look, we
Correct.
paid $240,000 to this individual. he only established that there was about $30,000 that was put into the project, and therefore we're entitled to the difference of that plus interest in addition to the what the jury awarded for the breach of contract. Is that
Correct.
roughly correct?
The lien law, as I said, is
Yeah,
very
okay.
prescriptive
Yeah,
with
we-
that. It says that any of our funds must be placed in escrow, and they can only be used for valid trust purposes, and until that point, they remain our legal property.
We recognize, we understand your argument, sir. We understand what you're asking for, and we'll take a second look at the briefs, and you'll get a decision from us.
I appreciate that. I appreciate your time, and
You have a nice day. 1051 Glock v. Albany International Court. Okay.
Good afternoon, Your Honors. May it please the Court. My name is John Lipsitz, and I appear for the estate of William McIntosh, who worked for the Gouverneur Talc Company from 1979 until 1988, during which time he was exposed to talc dust contaminated with asbestos fibers.
Yeah, let me ask you this. This is all about a duty, right? Is that?
Yes, sir.
Okay. So let me, I'm looking at all kinds of law and my head's spinning a little bit, okay? Because I see that, we're to create a duty in situations, there's different fact patterns. We've got peril cases, and this isn't a peril case, right?
Your Honor, this is a case involving the assumption of a duty under case law that goes back to time immemorial.
Yep, we understand that. So, when I look at the PJI, that's one thing. It sort of commingles the two, So we're not dealing with the old law school case where somebody's out there swimming and you go out to help them. This is an arrangement between two folks that somehow creates this agreement or this relationship, creates a duty to a third party.
Well, actually, we're dealing with both situations,
Okay,
Your Honor,
tell me
and they overlap. We're dealing with the law school proposition involving the drowning person. We're dealing also with a line of cases that started out with a case called Pelco and then was followed up by Espinal.
Okay, so tell me why. Let's deal with the peril case first. Tell me why, what your theory and case law to support it, how a duty could be created in your case.
Okay, Your Honor. The Vanderbilt assumed a duty, in this case, to communicate reasonably accurate hazard information to the employees of its subsidiary, Gouverneur Talc Company.
And how did they do that?
They did it by voluntarily undertaking actions that placed Mr. McIntosh in a more vulnerable position than he otherwise would have been. The duty that they undertook was to accurately communicate hazard information about the talc that Mr. McIntosh was working with to Mr. McIntosh's fellow workers, the supervisory staff at the talc company, and the talc company itself.
But do you see where my concern is? That's a relationship and an assumption of a duty that possibly could be created because of the relationship between the parent and the subsidiary that, the plaintiff maybe is a third party.
Your Honor, this is not a duty that was created in the vacuum of a relationship between the parent and the subsidiary. This is a duty that Vanderbilt, which happened to be the parent corporation, undertook upon itself with respect to the development, that is to say, the collection of information about the occupational hazard and the communication of that hazard information to the workforce, including Mr. McIntosh, who unfortunately died before he was able to testify in this case. So it fits within the framework of the cases that we've cited, including Glanzer, which is a 1922 decision by Justice Cardozo. And in the Glanzer case, it's very clear, and there are numerous cases that follow up on it, that it's ancient learning that one who assumes to act, even though gratuitously, may thereby become subject to the duty of acting carefully if he acts at all. And in this case, Vanderbilt.
1 second, Mr. Here's the concept I have in my head. I want to see if it fits with what you're doing. Under the restatement 323 and that case you just said, Glanzer, as well as Harvey, another case where they pick up the two gentlemen, they put them closer to the thruway.
Right.
Right?
Coleman Hill.
What's that? Coleman
Hill.
So the way I have it in my head is under 323 of the restatement that is a relationship that I've assumed directly to you because I've interacted with you, as opposed to Espinal, where my duty is really to the party I've contracted with, but you're a beneficiary under the law if you meet those three exceptions, and that's 324A.
Right.
I read your brief as being primarily focused on 324A and Espinal. Is that a fair statement?
Your Honor, it's really a hybrid situation. We have a company, Vanderbilt, which develops this information, and we contend lies about the hazard to the workforce. It's done in such a way, if you look at the testimony of Mr. Kels, who was the health and safety director for Vanderbilt, that all the information is funneled with the intention that it reach the ears of the workers, including Mr. McIntosh. In fact, there's even a meeting at one point where one of the Vanderbilt family comes to the plant, talks about the fact that it's a nuisance dust, and that it is not a situation where you got to worry about cancer.
But that's almost, as I hear what you're saying, you're making a total displacement argument under Polka, which is what Judge Merrill said, and if I recall the brief that was filed by the plaintiff's firm at that point, they said polka, 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 pike, 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 as I understand it. So it seems to me that you're really focusing on 324A and Espinal.
I'm not backing off of Palka and the Espinal.
You're saying this, if I understand. You're saying, look, there may have been an agreement between the parent and the subsidiary, right, which gets you to this Espinal. But in addition, there was some direct contact between the parent company and the employee by way of safety materials, fact sheets, and they were given directly by the defendant to the plaintiff. And so you're saying that gets you to your peril type case?
Yes, Your Honor. There's testimony from coworkers of Mr. McIntosh which say this is the information we got. There's testimony from a plant manager at the Tel Company who says, I got my directions from Vanderbilt, and that's all. And I wasn't really in a position to say, well, no, that's not right, or I had to communicate that information.
He didn't just say that he got his information from them. He said that he was not in charge of health and safety except to follow the instructions given by Vanderbilt.
And also, Mr. Kels, who worked for Vanderbilt, said, when he asked a question, did they always communicate what you wanted? He said, I'm sort of pleased to say, yeah, that over 30 years, they always followed my directions, and that information flowed to the workers. And we contend, Your Honors, that it was a lie. And that, essentially, and this, I haven't been asked about the Finnerty case yet, but Vanderbilt's invoking this Finnerty case.
Yeah, at least to me, I'm not concerned about Finnerty.
Okay.
I understand. Your argument is a different argument than in Finnerty. Your argument is getting back to basic principles of, the restatement of torts and Espinal and 324A. So let me ask you this. If, now moving on to the 324A or the Espinal, I read Espinal, there's a written contract. But when you look at the restatement of torts 324, which the courts have sort of suggested we've adopted that by way of Espinal and other cases, there doesn't necessarily have to be a written contract. So as I understand, I think I understand what your argument with the duty is that under either 324A or Espinal, you get there for two reasons. Launching a force, the agreement between the parent and the subsidiary, or the assumption of this duty by the parent for the subsidiary, plaintiff's employee, that somehow that what happened then is they launched a force, one exception under Espinal,
Correct.
Or 324A.
Or making the hazard worse, which is another way of saying launching the force, the instrument of harm.
And then the reliance exception.
That's true.
And you're saying any one of those, there's at least a question that there's a duty, and that's what gets them into the lawsuit.
Your Honor, also the displacement situation, which is the third situation in Espinal, which is one that Judge Merrill embraced in his decision in Pike. So we
But it would
have
have to be a total displacement, right?
Well, Judge Merrill said, no, it doesn't, it's a total displacement in the sense that
Well,
it
we don't-
relates to the particular communication of this kind of information to people that are put in a more vulnerable position.
Would
if
you
they-
have something that says that, that's a little bit, maybe an appellate division or Court of Appeals case? Judge Merrill's decision is a trial level decision, and my question is my understanding of the law is it would have to be a total displacement.
Well,
And did that take place here?
Your Honor, the question is a total displacement of what? There was a total displacement
Of this obligation, of this.
the obligation to accurately and effectively and truthfully communicate hazard information to people that were working in a dusty environment. That was displaced.
This is a failure to warn case.
In part, it's a failure to warn, but it's a lulling people into a false sense of security case. It's a failure to warn case.
By a failure to warn.
By negligently misrepresenting, by actually misrepresenting.
By nonfeasance.
Well, I would say it's an affirmative act to mislead people.
And
otherwise you
detrimental
don't
reliance.
There is detrimental reliance, and certainly, we contend there is based on the facts here, on any way you look at them, but there's at least a question of fact with respect to that.
Isn't the instrument of harm here the talc?
No, well, that's an interesting question. Of course, it was a contaminated place, right? But you've got these cases involving an actor that undertakes a duty. Let's say it's a duty, you're on the top of a burning building and you're a volunteer fireman and it's Wolf versus the City of New York, and the fire chief says, go over there, through the smoky and dusty atmosphere, and you climb over the parapet and you can get down safely. But he knows that there's an air shaft there, and the guy that he's directing doesn't know there's an air shaft there. Now that air shaft is there whether he's beckoned or instructed to go that way and ultimately fall down it, or whether he's not. So the fact that there's a contaminated and dusty atmosphere doesn't mean that there isn't an increased hazard or a more vulnerable situation, or launching an instrument of harm. You can say it that way, it's poetic, but it all boils down to the same thing. They're telling these people it's not dangerous. It's only a nuisance dust. It doesn't have asbestos in it. It won't cause cancer. And what do? They work with it.
You see why we're getting a little bit confused? You're commingling different theories, and I get what, I'm trying to marshal them for you. So in other words, if you want to talk about putting in a worse situation, that's really a peril case. If you want to talk about launching a force, I think what Justice Curran's question is it enough just to not tell somebody that a particular substance is bad for you? Hang on, let me finish. Or do you have to do something to change the composition of this dust, and that launches the force? We're accustomed to dealing with launching a force situations where, it's not that you didn't plow the driveway real well or the parking lot, but what you did when you did do that, and your contract was with the building owner, you did something else. You pushed the snow into the sidewalk. So I guess the question is what force was launched here?
Your Honor, it's not that they didn't warn them. It's not that they were silent or neutral. The employees, including Mr. McIntosh, were misled. There was inaccurate and untruthful information communicated to them.
So your argument is that's the force that was launched,
If you look at a 2016 case, and I believe it's cited in our brief. Here we go. It's the
Gelda. Is it Gelda? Was that?
No, I'm sorry, Your Honor. It's after Trinity in my notes. Here we go. It's Garda. Thank you. Garda versus Paramount.
Was that a second department case?
Yes, I think it was the second department.
And what were the facts of that again?
Well,
generally, briefly.
Let me make sure I'm citing the right case. The facts generally were that there was a gentleman who was working for Paramount Theater, he's an employee. He's told by another corporate entity involved here to go to the back of the theater, or behind the theater, and there's a person that's acting in a peculiar way, and you should subdue that person. So he goes back there to subdue the person, and instead of subduing him, he gets beaten up quite badly. And the court indicated that a duty of care may be assumed where, quote, a defendant's conduct placed plaintiff in a more vulnerable position than plaintiff would have been had defendant done nothing, or where a defendant's conduct enhanced the risk that plaintiff faced, created a new risk, or induced plaintiff to forego some opportunity to avoid risk. And clearly, here, these individuals...
What would you say that falls under? Restatement towards 323 or 324?
This is the person in peril.
That's 323.
Paradigm.
Right.
So, Your Honor, you asked me, you're trying to help me with putting this in a particular category.
I'm trying to help myself, too.
Well, I think what we have here is a situation where the defendant is trying to create all this sort of organized confusion about, well, you've got to find a particular pigeonhole to put this in, or you fail.
Well, that's what we do when we write decisions. So.
We don't have to, you can look at this case from multiple angles. You can look at it from the old paradigm involving the drowning man. You can look at it from the contractual paradigm involving Polka and Espinal, and it fits. It fits in the fact that they assumed a duty, they put the person in a more vulnerable position, and he got injured as a result.
And then you would say under Espinal, you meet it under 2 exceptions?
3 exceptions, Your Honor.
Okay.
All 3 of the exceptions, and I take issue with what Judge Merrill said about the first exception. And in any event, we pleaded that it increased the hazard, and we pleaded that there was detrimental reliance in our complaint. And our complaint is clear on that issue.
Does your duty argument rely on establishing as a fact that it was a lie? I think you said that a minute ago.
That's interesting. If they had told the truth, we wouldn't be here.
Maybe.
Well, if we had told the truth, we wouldn't be here.
Depends how GTC reacted.
No. Well, all right. But this isn't a product. This is not a product's liability case involving a product put out onto the market.
Yeah, we know that.
Okay.
We know that the other case is not applicable.
So really what happened here is that, well, what they want you to do is say it's okay to concoct and feed employees of their subsidiary false and misleading information about the hazards of mining talc, and in that you can do so with immunity to liability for common law negligence in tort. That's what they want.
They failed to tell the truth.
They absolutely, they misled people.
Well, you would get, the point then is it misfeasance or nonfeasance?
No, it's
There's an
lying.
interesting decision by Judge Mark Dillon down in the second department called Santos from 2016. Nobody cited it, but I remember when it came out, and it talks about this whole issue about what does launch mean? And your argument is the launch is the lie.
Certainly is
The other way to look at it is by not telling the truth, you remain silent, which is inaction. So that's what we have to look at.
If they had remained silent, there would have been no assumption of duty under my understanding of the case.
Okay, Counsel. Thank you.
Thank you very much.
Good afternoon.
May it please the court, Pratik Shah for defendant, respondent, Vanderbilt Minerals. We've been talking a lot about the 2 sorts of cases, the peril cases and the contract cases, 323, 324. We would submit, Your Honor, that you don't even have to get there because of 2 other doctrines, the worker compensation regime as well as the veil piercing doctrine.
Yeah, so they're not trying to pierce the veil, so you win. Right. Okay?
Well, Your Honor, if I can elaborate on that, their complaint, their briefs, and everything sounds in veil piercing. I know that they're saying we're not trying to pierce the veil because if they did, they would lose under the exclusivity.
You're not suggesting that just because they're arguing creation of a duty that didn't otherwise exist against a parent corporation, you're just prohibited because your only alternative or your only remedy is to pierce the corporate veil.
No.
They would be making this argument if you folks hired some third party to come in and do exactly what the parent company did.
Sure, Your Honor. We're not arguing that you can never sue a parent company in any situation. We're talking about the situation here.
Yeah.
Here's what they've alleged in their complaint. They've alleged that Vanderbilt exercised complete control, utterly usurped the subsidiary's occupational safety program. That is based on their own words that we've quoted in their complaint, their briefs. If that is true, that in fact Vanderbilt has exercised complete and utter control over the subsidiary's occupational safety,
and they're stuck with comp.
Exactly. Then you run into the exclusivity bar. And in fact, the case that they keep pointing to, the trial court case in Pike, the judge there found that the plaintiff's allegations read in the light most favorable to plaintiff would be a complete disregard with respect to worker safety occupational health program of the distinction between the parent and the sub.
Okay, what if we can't get there?
Okay, so if you don't get there, then they run into the veil piercing doctrine. That is the limitation on liabilities of parents. That is, if you're not going to pierce the veil.
Yeah, that's what I'm talking about.
Right. Then you run into limitations, traditional, well-worn limitations on putting liability on a parent corporation when the theory is based on parental control of a subsidiary short of veil piercing. That is their theory throughout this case, that Vanderbilt has exercised significant control over the subsidiary in taking over the testing.
That's one of their theories. I'm looking at their sixth cause of action right now.
Right, and that's in the...
And I'm looking at paragraph 80, and they say Vanderbilt took complete control and responsibility for coordinating, et cetera.
Exactly.
And then, however, you keep reading,
right.
And if you go to paragraphs 84 and 85, they switch to launching an instrument of harm, essentially, and I would say 85 is invoking out of safety the reliance. Clearly, this complaint was drafted in light of Pike.
Right, Your Honor, it was drafted in light of Pike. Pike was decided under Finnerty, and Your Honor, I understand Finnerty, this context of Finnerty was products liability. I'm not saying that you, just because Finnerty is out there, but Finnerty is adopting veil-piercing doctrine and applying it in a particular context. And I think the arguments and reasoning, if not the four corners of Finnerty apply here when you're talking about a claim short of veil-piercing, but it's based on a parental control of a subsidiary, whether that's launching a harm. Now, and if I can walk through the similarities.
Let's not go to launch yet.
Okay,
Let's
so I'll
stick
stick
with this displacement, because I understand your argument. If we say, okay, yeah, there was displacement, and we're going to go with Pike.
Yes.
Then we have to default to the workers' compensation, and I suppose there's probably case law out there that says we stay the case and defer to the jurisdiction of the comp board.
In fact, you dismiss it because whatever happens in the workers' compensation, that's a separate regime, and that's your exclusive remedy, whatever you get there.
So like Justice Carney said a second ago, assuming we get beyond that, let's talk about the launch.
Okay, so before you get to launch on Finnerty, why the reasoning and arguments are there. So short of veil piercing, we're not in the exclusivity bar. Then we're in traditional veil piercing doctrine. What the plaintiff argued in Finnerty is exactly right there. They said, look, we're not trying to pierce the veil, but the parent corporation exercised, and this is a quote from Finnerty, significant control over the subsidiary so as to pressure the subsidiary, take over the functions of the subsidiary, play a significant role in the subsidiary's manufacturing and selling process, and therefore we should have direct liability, not derivative liability.
Are you saying that we need to follow Finnerty in order for you to be successful on this appeal?
No, you don't have to, but I think there's three ways in which we win, right? They're stuck between three different regimes. The workers' compensation regime, so if you go down, take their complaint at face value, and they actually have displaced.
It's not really three ways.
Okay.
It's, you're either going to, your argument is by the allegations of this complete displacement, you're either getting to pierce or you're getting this other doctrine of parental control over the subsidiary.
That's right.
And in either event, then workers' comp comes into place.
Yeah, in the first scenario, workers' comp, or the second.
The second.
Right, right.
And then I know that's that's what you want to get to, because you don't want to talk about all these other things that he was talking about.
Yes.
And I want to talk about those things, so.
Sure.
You know, are you done making your arguments about this parental control and this piercing the corporate?
Yeah, the one other thing I'll add on that, just for the benefit, if it helps, is Finnerty, again, even if you don't say the four corners of Finnerty, Finnerty is building on a whole lot of case law. I
understand. You want us to take the portion out of Finnerty, not the products case, but the analysis as to parental control or piercing the corporate valve. And you say that's good, solid law in New York State. They're stuck with it, and we go no further.
That is exactly right.
I got it.
Okay, great. Now, to be clear, when you go down that, we're not saying that Finnerty or anything else means that you can never recover against a parent corporation, against a subsidiary. We know there are cases out there. They've cited them, right? Bernardo and Samaras. Those are the only two cases out of all the dozens and dozens of cases you have cited in your brief. There is not a single appellate decision, not a single one cited, where you recognized a parent company's duty, absent veil piercing, to a subsidiary's employee based upon the parent's control of worker safety. They only have 2 cases of parental liability to a subsidiary's employee for worker safety, Samaras and Bernardo. Both of those are not negligence duty peril cases or Espinal-Polka cases. Those are property owner cases.
Yes,
if you are a property owner, you incur an independent duty as a property owner.
No, we understand.
Yeah.
Well,
so,
because if you're a property owner, we wouldn't be having this duty conversation because there's a non-delegable duty to keep your premises
exactly.
safe.
Those are the only appellate decisions out of the dozens of
So
cases.
what you're saying is the reason we don't have any cases that apply Espinal 324A or 323 to a relationship where the parent company takes over the duties of the subsidiaries because it just can't be.
That's exactly right, and that can't be because of the 2 doctrines we've talked about, workers' compensation and veil piercing. When you are basing your theory as they are on a parent's assumption of duty of the subsidiary.
So maybe you don't want to talk about the other stuff that he argued.
Right.
Because you say once we go down that road, you've got problems and we're not following the law of the state of New York.
Exactly. That's why they have 0
I understand.
cases. That's it. Now, I'm happy to talk about those other doctrines. I don't think they're applicable, but even if they were on their own terms, and this gets to Justice Curran, I guess your questions that you were talking about launching harm. So I guess 2 points there. One is the 324A criteria. When you're in a contract case, then Espinal says, look, any one of these 3 criteria, you meet them. Again, not parent subsidiary, but just like.
Is there a contract here?
No, Your Honor. We're not at a motion to dismiss where they can just kind of allege a contract and we're done. This is summary judgment.
Yeah, because, it seems like Espinal really emphasizes the contract.
Right.
But then 324A of the restatement of torts, which everybody sort of suggests that Espinal's adopted. Not everybody, but it seems like there's cases that suggest that. There seems to be a little bit of a difference because it seems like in Espinal there's a need for a contract,
Yes.
whereas 324A is a little bit looser with the law.
Here is the nuance, Your Honor, that you put your finger on. Espinal absolutely requires a contract. 324A encompasses both contract cases and non-contract. Just on the face of 324, it says, this provision, we're going to be talking about gratuitous cases, non-contract cases, as well as contract cases. New York courts, however, have only adopted 324A in the contract context.
Right.
We have on page 32 of our brief where we lay out.
I understand, because I was.
What case says that?
So it's on page 32 of our red brief, Your Honor, where the New York law, it's there isn't a case that expressly rejects it, but
Because I
Creamler.
looked, I couldn't find it.
Yeah, so I think the best case I would point you to is the Nayland case. It's on 32 of our red brief, and here's what it says.
Is Nayland the case, the Hemsley case?
Yeah, so it's a.
Well,
and-
the
okay,
Hemsley
that's
case, it's a premise case too, isn't it?
It is also a premise
I mean,
case.
it's a hotel that they own.
That's right, and we also cite Creamler, which kind of does the summary of New York law, and it distinguishes the voluntary undertaking from the contract Espinal cases. Again, it's well established under Espinal. 324A applies when you have a contract in New York, but you cannot get around, and this gets us back to Justice Curran's question, when you don't have a contract case, and again, we're on summary judgment, not on a motion dismiss, there is 0 evidence in the record of any contract. There just isn't a contract, neither expressed nor implied. They don't even mention any potential consideration or anything like that.
So we don't even get into the exceptions?
We don't get into that at all.
I'm looking at Espinal, it's, number 1 says, we're the contracting party, et cetera, et cetera.
Yes. Espinal, I mean, it is pellucid if you read Espinal that it's all premised on the contract, which isn't existing here. And if you look at their reply brief, I mean, again, summary judgment, we've had briefing on this, we've had evidence, we've had discovery. We come back in our brief, show affirmatively no contract, no consideration, none of the analytics to get to implied, and they really don't take that on at all. And so that sort of ends, in our view, even if you got past workers' compensation doctrine, veil-piercing doctrine, all of those cases, and you got to this doctrine, that still doesn't apply for the reasons that I've discussed. I'm happy to answer any further questions.
Thank you, Counsel.
Okay, thank you, Your Honor.
1051.1, matter of Rochester Police Locust Clubs versus City of Rochester. Good afternoon.
Good afternoon, Your Honors. I'm Andrew Celli. I'm here with my partner, Debbie Greenberger, and we represent the City Council of the City of Rochester. Your Honors, 9 days before voting is to commence in this city, the Rochester Police Locust Club asked us...
Well, Counsel, let me just say, as you've been a long day, and we're familiar with the record.
Okay.
And your latch in the argument, filing late, let's just assume we get past all of that, because there is some distinction between the Control case and the case that this was done months before as opposed to just before the statute. And you've addressed this. I'd like you to talk more about the irreparable harm. I mean, we understand what the standard has to be for a court to grant the injunctive relief that they've requested here.
Right.
And you seem to spend a lot of time and really hit home on the irreparable harm issue. And that's what, I'm not speaking on behalf of the panel, but that's what kind of, I think my focal point is on the, could be a dispositive or not dispositive issue.
Well, Your Honor, to be clear, it is the Locust Club's obligation to demonstrate that they will be irreparably harmed.
Yeah, right.
Okay, Justice Ark kind of put it the other way, like what was our problem? And I think there will be no irreparable harm because the way the statute is designed, it does go into effect if the referendum passes. So we have step one, if the referendum doesn't pass, nothing has happened to them. Step two, if the referendum does pass, it goes into effect immediately. But by its terms, there's about a 60-day period during which the Police Accountability Board is constituted. It's a fairly complicated procedure. Several different constituent groups, there are nominations.
Appointments.
That's right.
And so in essence, assuming that it does pass, then you find yourself in a situation where the merits of the case can be litigated.
Yes,
constitutionality or whatever legality of the law can still be litigated.
Exactly. That would be what Cantrell would teach us.
And that's assuming that it passes.
Correct. And if it doesn't pass, we all go home and it's all fine. But if it passes, and this is a case that's really quite different from the Rochester Central City School District case, where there had to be an act of the legislature.
Well, I think a little more than that is that we got to the merits on that case.
Right.
And we were able to address the merits, which ultimately did away with the injunctive, or dealt with the injunctive relief, because we got to the merits. Here, we don't have the merits before us.
That's right. I mean, we're prepared to address the merits.
Well, the problem is the court did.
Exactly.
Okay,
That's a major problem.
Yeah, that's a major problem, which I was on. We didn't have that with the Rochester City School District, whereas if the merits before us, we could address the merits and/or to see whether or not the injunctive relief going forward should be there.
The absence of irreparable harm is dispositive. The absence of likelihood of success is dispositive. You don't have to reach any other issues, but you could even go more conservative, if you will, with a small c, and simply uphold the automatic stay, the 5519A automatic stay that applies in this case. That would stay the court's order. The election would occur if the referendum passed. Justice Ark could be directed to conduct the review that he should have conducted, and that he actually kind of suggests. I mean, to be fair to Justice Ark, he was put in a difficult position because the ballots were about to be printed. And so he had to say something one way or the other. His error was to essentially grant an injunction without meeting any of the standard. But that, it seems to me, would be the most protective, the most regular process to simply affirm the automatic stay, permit the election to occur. If the referendum passes, send it back to Justice Ark and let Justice Ark rule on the merits, on the likelihood, on the merits of the challenge. They are seeking to challenge a duly enacted piece of legislation. They're trying to stop an election in the process, and they're trying to get this court to use its equitable power to do all those things. All of them are extraordinary. Any one of them would be extraordinary, but they need you to do all three. Our view is you should take a very limited view of this and uphold the 5519 automatic stay, send it back to Justice Ark, and we can all be back here, if necessary, in November or December. Now, I do have a whole presentation on the merits, but I'm happy to not get into it.
Our problem is that the court didn't decide it. How are we going to decide it? It's not properly before us, is it?
I don't think it's properly before us. I agree with that, Your Honor.
And so all you'd be asking us for is an advisory opinion.
I would never ask a court for an advisory opinion, unless it were going to help my client. In this case, it wouldn't. So if there are no further questions, I'll be seated. Thank you.
Patrick Beath for the City of Rochester and the Mayor.
Dan will be up in a moment. We're prepared to rest on our papers. Really, our arguments in the papers cover what we've just discussed with Mr. Selly. So unless the panel has any questions for me, we're prepared to rest on the paper.
Thank you, Counsel.
Thank you.
Good afternoon.
Now it's my turn.
What is the irreparable harm here?
I think the irreparable harm issue, and this is one of the issues, one of the reasons why there was some delay in bringing this, is uncertainty over the irreparable harm aspect. And I think that was resolved as a matter of law by this court's decision in the city school district case, because although the procedural manner in which that case proceeded did away with the need for a preliminary injunction, it still requested and obtained from the lower court, which was affirmed by this court, a permanent injunction. And
Well, we got the permanent injunction because we addressed the merits.
But a permanent injunction still requires a showing of irreparable harm for the equitable relief. It's actually a higher standard on the permanent injunction. So I think that it's the same issue of, do you allow a referendum vote to go forward on an impermissible piece of underlying legislation? And that's why I think this court's decision on that.
Can it be irreparable if at this point it's uncertain as to what the voters will do?
Yes, but I think the city school, this court's decision in that case was saying there is an irreparable harm in and of itself from holding an improper advisory referendum. That in and of itself is a harm, and it's appropriate for a court to step in and issue an injunction to keep it off.
I thought we decided in that case they couldn't do what they were trying to do.
Correct.
Okay, so I mean, so of course it can't go forward.
Well, but see, so.
Because it's the merits of it.
There are two components of the merits in the city school district case and in ours.
But here, the lower court did not deal with the merits.
It didn't deal with the merits specifically, but.
So how do we deal with them?
Well, you deal with the merits as a component, not in conclusive fashion.
I know what you're saying, as to
But as a component of the likelihood of success on the merits.
Irreparable harm, likelihood of success.
Correct, because without the irreparable harm issue, this court and Judge Odorizzi in the city school district case would have just issued the declaratory judgment that the proposed referendum is invalid. They would not have then issued the injunctive relief of ordering it kept off the ballot. That's a separate component, a separate claim for relief, and it requires the irreparable harm. So by granting it, this court, at least implicitly, recognized there is an irreparable harm to holding an impermissible referendum in and of itself.